file gone from the court. Yes. Where? The system, from where where is the physical file? Because December, see, 23rd December I passed an order, file was there. So how the file is not here? Where the file has gone?
My lord,
My
I have
lord,
lordship
may I
kindly leave
permit
to
to
mention.
mention matter?
My lord, I have mentioned before your lordship on 5th January.
Ah.
My lord, considering the urgency, your lordship were pleased to direct the matter will appear on 27th. But my lord, officer is not giving because he is saying not anything is not found, my lord. It's
Why?
extreme.
Where is the mentioning list?
My lord, mentioning list.
What is the urgency?
My lord, urgency is, my lord, the KMC authority terminated my company, but they are not releasing 2 machines where I am losing every month 10 lakhs. My lord, I am
Give.
My lord,
grateful to you.
हमको शाम को लाके दीजिए मेरे को FI ये जी मेरे को चैम्बर में लाके दीजिए.
my lord, item number 64, 65 and 66, my lord. Again, the blocking of the e-challan case, my lord. Again, the blocking of the e-challan case. They are imposes the fine of 1 lakh rupees without issuing the so-called notice prior to imposition of penalty. My lord has passed 4 or 5 cases order, my lord. All the trucks are on the road. If your lordship takes any date as is to be mentioned, my lord.
Not to be mentioned. Today there is no other matter. I will take. If it is not reached today, tomorrow Monday it will come. Don't worry.
I am handing over the slip, my lord.
It is there. I will take the matter.
Yeah, I am handing over the slip, my
My
lord.
lord, under comparing circumstances, I am mentioning item number 80 of days lease, my lord. It is marked as file not here, but it is marked as a file not here. But although, my lord, I mentioned before your lordship on 6th of January, when the matter was placed under the heading motion.
That's why I am telling.
Kindly see, my lord.
That's why I'm telling that now I have to come at 4:30 here to search the files and it is to be listed. That is only remedy now. I have done all the things. I reported to the RG. I reported to all the officials, but I failed. So now only the remedy is that after the court hours, I will come with the half pant and T-shirt, and I will trace out the file, and then your all the grievances will be pulled. That is only remains here in this court.
My lord, forgive me, lord. Just my lord, being satisfied the urgency, lord, your lordship fix this matter today. Lord, next week, my lord, any day, kindly, lordship, your lordship, kindly.
That's what I'm telling. If I will come with the half pant and T-shirt and I will trace out the file, it will be Monday. It will be listed. That is only because what can be done? Neither the RG is hearing my grievances, nor the staffs are hearing the grievances, not the deputy secretary, nor the joint secretary. What can be done? So only the remedy is that I have to take the file, I have to hear the advocates, I have to hear, dictate the all the things is to be done by me only.
We must say sorry.
That's the situation of the Calcutta High Court of Court number 25.
I beg your pardon.
My lord, I'm seeking to file. I'm seeking to leave to file and move this application on Monday. In this matter, my lord, the petitioner is president of the NGO and have already.
You have gone through the cause list. Today is not a mentioning date.
No, my lord, I'm seeking leave.
What? Why? What is the urgency?
That is my petitioner is submitted every document, that is e-challan and audit reports.
What is the urgency?
Matter the registration renewal.
Registration renewal. What registration?
This is the NGO, my lord.
NGO registration is a urgent matter.
No, my lord. The other committee member is trying to create a new member of the committee.
File it and mention it. File it in the department.
Lord, may I seek your lordship's indulgence, Lord? Lord, your lordship, in fact, not considering the urgency fixed is on 6th.
Yes.
Fixed the matter on 6th, Lord. Lord, this matter relates to Lord that SIR. Now, Lord, appellate authority directed them to Lord provide us all circulars based on which this is being done, Lord. Not provided. That's the urgency. Yesterday, Lord, my wife has received a notice again, Lord, to produce Lord, all passport and etc. Lord. This is harassment. Can it be?
You have gone to the newspaper. Go with all the trunk, with all document. Yes, the authority will see which document is necessary, and they will do that. That is going on here.
Well, can it be any day before 6th? Is it possible? Because 14th,
and what?
as your lordship pleases, Monday, Tuesday, any day as per lordship.
It is already fixed on 6th.
6th.
So why not 6th?
Because my after 6th, only 2-3 days will be remaining. That final list will be
तो एक काम करो, मंगल को रख दो, मंगल को top 5 में रखो.
Mongol.
May I be permitted to mention a matter for correction?
May I be permitted to mention a matter? This is not the mentioning day. I'm aware that this is not the mentioning day. I could have mentioned on another day. Item number 448, my lord. This is in violation of the TRI guidelines. Google, I am an NBFC. I need to give information to my customers in regard to how much money has been credited, how much has been debited in the account, the statutory, and there's a statutory number. What you want? But my number is being classified as spam in violation of TRI guidelines by Google. If it can be upgraded, my it's item number 448 in today's list, my. Come on Monday, I will see it.
Lordship, may I permit to mention matter for inclusion? Lordship, the urgency is that the concerned authorities.
Monday already, this monthly list will be published. If it is not published, come on that. Yes, call the list.
No, item 1, I appear on behalf of the petitioner. Lordship will permit me to address my lord virtually today.
Yes.
Lord, this is for extension of interim order. It was first granted on 23rd of November 2023. It's been last extended on 27 November 2025.
The only thing that extension I cannot oppose. I am for the respond number 2. This has been extended for 14 times, my lord.
Your lordship can have it fixed any day for hearing.
What is the
I didn't
matter?
count the number of days it's been extended.
Mr. Banerjee, what is the matter?
Well, this is regarding RERA, whether once a project has received completion certificate before the RERA has been applied in West Bengal, whether the act will apply or not. This has been heard threadbare by my lord Justice Bhattacharya.
Affidavit is completed.
Yes, my lord, it's ready for hearing. Lordship can keep it any day, my lord.
That is my only humble prayer. If any day, subject to your lordship's convenience, can be heard out, my lord. The matters listed to be mentioned on the prayer made by the counsel for the petitioner for extension interim order. Learned counsel for the respondents raise objection and submit that though the pleadings have been completed, but time again the petitioner is praying for extension of time instead of argue the matter on merit. Had the learned counsel for the parties peruse the document, this court find that peruse the file. This court find that affidavit is completed and matter is ready for hearing. In view of the above, let the matter appear on the date है डेट है First April 2026 at 2 p.m. as a specially fixed matter. Interim order is extended till 6th of April 2026 or until further order, whichever is earlier.
Extremely
Grateful, no?
Next.
item number.
Yes.
Lord, in item number 2, my lord, I have filed an application for addition of party.
Addition of party.
My lord,
Have you received the copy of the application?
my lord, to the petitioner I have served. I have served upon the petitioner. We are, my lord, the untainted non-teaching staff. My lord, this petition is with regard to, my lord, there was a benevolent scheme, my lord, notified by the
and nothing, no benefit was given and related to constitute initiate a new selection. What the government did, my lord, if my lord they feel that those appointments who have been declared null and void, they will get a remuneration from state exchequer till a selection process is initiated or the Supreme Court dismisses the review. The review petition Supreme Court has already before that, this honorable court can suspend my lord, state the operation of the.
my lord, on merits, my lord, we will argue, my lord, kindly implead us as parties, my lord, because we are the untainted non-teaching staffs. My lord, we,
Did you receive the copy?
my lord, I have, yes.
Yes. What is the contention with addition of party?
It is
Their application will be released.
Where is the application? Application is here.
Can 1, my lord.
No pen. Okay, I am fixing a next date.
My lord, my lord.
Affidavits completed? No.
No.
Who is for the state?
I have sought for it. Advocate General appeared, my lord.
They will not file any affidavit. There is no direction.
Well, there is the direction on the first day also, and the 19th September order, if your lordship kindly see.
19 September. Yes. Time to file affidavit of extended till 21st November. No affidavit is filed. Huh? Already twice the entry this direction is extended. 9 September till 21st of November. 5th December. We got the matter list has to be mentioned on the prayer made by the counsel for the petitioner for extension of interim order. What's your good name, sir?
My lord, Debashish Banerjee.
So appearing for submit that he has his client has also filed an application being Can 1 of 2025 for addition of party. Full stop. It is fine from the record that this court has passed an order for exchange of affidavit, but as per the report of the mandamus section, no affidavit is on record. Consider the submission made by the counsel for the parties for the interest of justice. Time to file affidavit in opposition is extended for a further period of 2 weeks from date. Reply, if any, thereto within a week thereafter. Full stop. List the matter on 2 week, 1 week, na? On 25th of February 2026 under the heading urgent motion. Interim order is extended till 27th of February 2026 or until further order, whichever is.
Your lordship is allowing our application.
Can be the application for addition of party being Can number 1 of 2020 be placed with the record on the next date.
My lord.
Only one thing here. Can your lordship kindly take that copy of this order? I will communicate to the government office of the government.
The petitioner is the learned counsel appearing for the petition director to communicate this order to the respondents for compliance.
My lord.
Next.
Lord, this has come at my instance. Your lordship knows, my lord.
What is the correction?
Direction personal appearance.
Personal appearance of
Registration.
It was not necessary because
Register.
my report was with me. I was stuck up at court number.
So that's why none appears. What can be done? Where is the report?
One thing. Another thing is one correction is required. God to order
একটা
2nd of January.
Yes, you serve the copy to them.
Yes, I'm serving there now.
Yes, what is the correction in 1st January, 2nd January?
2nd January, my lord, your lordship has been kind enough to, my lord, observe that 2 lakhs
2,75,000.
Yes, looking at page 61.
Yes.
This is value of the property. And from the report, your lordship will find, my lord. Adhesive is required 19,500. That inquiry.
Okay, I will see to that. You serve the copy.
I have to.
So the matter list has to be mentioned on the prayer made by the counsel for the respondent by an order dated 27 January 2026. As none appears on behalf of the respondent and no report was filed, accordingly, this court directed the Registrar of Assurance, Calcutta, to appear before this court in person on 3rd of February 2026. Now the respondents have filed the report after serving the copy to the London Council for the petitioner. Accordingly, the order dated 27th of served to the petitioner. Let the report be kept with the record. As the respondents have already filed their report. Accordingly, the order dated 27 January 2026 is modified with regard to personal appearance of the Registrar of Assurance, Calcutta on 3rd of February 2026. Let the matter appear on 3rd February under the same heading. Let a take query then. Next.
The petitioner, my lord,
I am for the state, my lord, led by Shabnam De Barbadhan, Junior Government, Learned Junior Government.
Item number
4.
Non-prosecution.
not have been settled, my lord.
Non-prosecution.
Yes, my lord. Will be. My lord, that's my terms, my lord, in accordance with the terms of the.
There can be nothing better than this.
Not better for us. Not better for us. Not better for us.
I beg to
I'm
request
saying that, my lord. They are saying, my lord.
at a copy to you.
Yes.
Kindly give a copy to her.
একটা কপি
শেষ হয়ে গেল কবে দেবে
হ্যাঁ নিশ্চয়ই নিশ্চয়ই My lord, all disputes has been settled between all the parties here, my lord. Hearing, my lord.
What is a claim in the writ petition?
My lord, it's huge. My lord, the setting aside of an order of, my lord, July 30th, 2025.
is with regard to the WAP property.
All the parties have, in good sense, have settled the disputes, all the disputes, my lord.
The
My lord, there was a direction of filing opposition, affirmed copy served. May I file this?
file it when I sure. The listed as to be mentioned on the prayer made by the council for the petitioner. For petitioner full stop. When the matter is called, the London Council appearing for the parties have handed over the memorandum of understanding entered between the parties dated 24th of January 2026 and submit that the parties have settled their dispute outside the court and have entered into the memorandum of understanding on 24th of January 2026 and thus after entering into the memorandum of understanding, nothing remains in the present date application and played for withdrawal of the respondent number 1, 2, 3 and 4 have filed their affidavit in opposition. Let the same be kept. As the parties
already filed.
as the parties have settled their dispute by entering into the memorandum of understanding that and the petitioner is not intending to proceed with the present writ application according WPA number 2210 of 2025 is dismissed, has withdrawn. The memorandum of understanding will kept in the
My lord, kindly record my appearance for the state, Vijay Agarwal, led by Shabnam De Barbadhan,
Yes.
Junior Government, London Junior Government.
But state respondent.
State respondent, my lord.
Give the name.
My lord, on 15th, my lord passed an order in which my name is, my appearance is not mentioned. Kindly record it, my lord.
To add a line, my lord.
On 15/12, my lord.
Settled and entered into the agreement. That has recorded.
I'm grateful.
Grateful.
My lord, kindly record my appearance on 15/12.
Call. Next call.
Yes. I'm for the respondent number 7, man.
In this matter, my lord, I'm appealing for the petitioner. My lord, this before your lordship proceeds, my lord, I have to file a supplementary affidavit because it's an old matter, and my lord, there are subsequent events which has happened. But this is a matter in which my municipality has encroached the land of the petitioners. My lord, without having any acquisition or anything has been done. My lord, I am on a very fundamental question of law. My lord, if a municipality being a body of a state, if he encroaches, it has to be done by way of an acquisition. Now, in the meantime, my lord, subsequent events has happened. My lordship grants me a liberty. I'll file a
2019 matter, I will not leave.
One
This is to be disposed of.
Yes,
one
yes.
small thing, whether my lord would have determination to hear this matter.
What is the matter?
This is the hearing.
The prayers
Yes, yes.
made in the writ application are against municipal authority, my lord. Whether my lord would have determination.
Just a minute. Let me see.
Respondent number 7. Private respondent একটাই তো আছে।
অসীম শাহ।
এই তুমি এখন municipality
হ্যাঁ, ছুঁয়ে resolve হয়ে গেল।
হ্যাঁ, সে তো জানি।
Yes. This court is not having the
No, this is a hearing matter, my lord, probably.
hearing might
My lord
be
has
not
determination.
parted by this court.
My lord has determination of hearing matters from 2023 onwards. This is a 19 matter.
Irrespective of the irrespective of the classification, 23 onwards.
Very well, my lord. Then, my lord.
This court find that
এটা তুললো কেন তোরা এইবার?
the grievance made by the petitioner in the present writ application,
My lord, this is a residuary matter under group 9, my lord.
kindly come to the prayer.
My lord, prayer is
Municipal
there. No, my lord, what has happened, my lord? My lordship will give me 1 second. My lord, although this has been filed in group 9, my lord, we have prayed for, my lord, in respect to that whether I am required to possession or not. Lordship can decide it on the basis of a report. My lord, my only grievance is that, my lord, whether municipality has acquired it or not.
Correct. You are this your glance is against the municipal authority. Municipal authorities encroach your property without acquisition of the
Yes,
property. Now, any order is against the municipality.
Yes.
For the municipality, there is already a specific determination of the court. So
Then, my lord, lordship will kindly, my lord, give me liberty. The let it be, my lord, appear under the group 5 only, my lord.
grievance of the petitioner in the present writ application.
My lord, then a
against the
presentation form has to be correct.
and thus this court is not having the determination. Accordingly, the writ petition number so and so is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Grateful, man.
Yes, next.
I appear on behalf of the petitioner. So, my lord, this the matter is dismissed for default on 13th of June. I filed, my lord, the application within that time, my lord.
Yes.
On my application for, my lord, the restoration, the matter was dismissed for default by the Honorable Justice Amrita Sinha on 13th of June 2025. And now, my lord, within 1 month, I made.
So when you filed an application for restoration,
my lord, this the 11th of July.
why you not appeared?
My lord, this the my lord, this the
What is the prayer in the writ petition?
My lord, the prayer for writ petition. So now, my lord, is kindly come to this for renewal of the my
Renewal of
my lord, the fertilizer license. Last, my lord, 20 years he has been running with the valid license of the, my lord, the fertilizer.
Where is that? Where is the license?
Now, my lord, kindly come to page 50.
50?
1-5.
I have no copy, lordship. This is a writ
What?
petition. Now, my lord, this is the
He has submitted the bill, my lord, the bill before the authority
no,
concerned.
no, he is the he served the restoration copy on the before 1 month, lordship. No, I have no copy.
Now, my lord, second copy I am handed.
Give.
So now,
Where is the representation?
my lord, my lord, this the application has been considered and forwarded page 23. Page 23. My lord, this is the Bengali vernacular. My lord,
Who has forwarded?
forwarded, my lord, on 20th of June 2019.
Who has forwarded? Assistant director?
Yes.
To whom?
My lord, this is forwarded to the assistant director. My lord, this is the issuing authority.
Assistant director is forwarded. Where? Who has? To whom it was forwarded?
My lord, assistant director, Administrator Tomlu, for take necessary steps.
Assistant director of agriculture.
Agriculture.
Tomlu district of subdivision.
Assistant director of agriculture,
Hmm.
and he has forwarded to, my lord, the assistant director administration. Kindly, my lord, bottom, my lord, is the page 90.
Then
Not taking this, but till this date, the authority concern has not been considered, though I have the, my lord, the other license which has been issued by the authority.
petitioner has filed the present application being Can 1 of 2025, praying for praying for recalling of the order dated 13 June 2025, wherein the petitioner has prayed, wherein the writ petition was dismissed for default for non-appearance of the parties when the matter was called. Counsel for the petitioner submit that when the matter, why you are not appeared? Submit that.
Due to illness,
That the learned advocate appearing for the petitioner was ill and could not reach this court, due to which the petitioner could not appear before this court. When the petitioner came to know that the petition was dismissed, immediately the petitioner has filed the present application. Had the learned counsel for the petitioner parties peruse the application, this court find that sufficient cause has been shown for non-appearance of the petitioner on 13th of June 2025. Accordingly, order dated 13 June 2025 is recalled. WPA 7500 of 2024 is restored in its original file. Can number so and so disposed of. With the consent of both the parties, the writ petition is taken up for hearing for final disposal. This court find that the petitioner, the respondent authorities have provided the license to the petitioner for selling fertilizer in retail shop. Before the expiry of the license, the petitioner has made an application for extension of the license period, and on receipt of the application, the assistant director of agriculture within bracket ADMN has forwarded the same to the competent authority for consideration of the application for grant of for extension of the license to the petitioner for selling fertilizer. Full stop. In spite of thereafter, the petitioner has made several requests to the authority, but till date, the request of the petitioner has not been considered. Full stop. Full stop. Learned counsel for the respondent submit that the petitioner has made the application only a month before the expiry of the registration certificate. And as such, it is not possible for the authority to consider this. Had the learned counsel for the respective parties peruse the matters on record, this court find that no purpose would be served by it. This court find that no purpose should be served by keeping the repetition pending. According the repetition is disposed of, directing.
Respondent number 4.
Directing the respondent number 4 or any other competent authority to consider the representation submitted by and consider the application submitted by the petitioner, followed by the representation for extension of license for selling the fertilizer within a period of 4 weeks from the date of receipt of the order by passing a reason in speaking order after giving an opportunity of hearing to the petitioner. WP is disposed of. Next. Yes.
Please, my lords. My lord, Mr. Mukherjee's concluded his submissions.
Yes.
I'm supposed to give a reply. My lord, I will only just stick to the points. I will not re-argue what has already been argued.
Yes.
My lord, the principal case made out by the petitioner has not been addressed by the respondent bank. The principal case is there is an RBI circular. The RBI circular has certain rules regarding charging of penal interest, which no bank is
He
entitled.
has given the answer to the penal interest, if at all, if the penal interest is left.
Lordship.
Again, also you have the claim, the
Lordship.
amount which is lying.
Lordship.
That is again it will be NPA. What is the answer to that?
Lordship. The answer is very simple. My lord, this how much is exactly what Mr. Mukherjee showed was my total due. 6 crore odd, etc. Now, my lord, lordship knows it is elementary that in a loan, at any given point of time, you have a final amount which is due, and you have amounts which you are required to pay from time to time. My lord, let's say on 20th June 2024, I have 6 crores due. It does not mean that I have to pay 6 crores. It means I have to pay the amounts, the installments, as and when directed by the bank. Mr. Mukherjee has not addressed that at all. Malad, he has shown that I was required to pay 6 crores is on that date. Therefore, penal interest does not alter the equation.
So as per your submission, what would the amount due cannot be treated as an NPA?
The total amount which is due, unless lordship.
As per their claim, 6 crore something, 90.
Well, that is the total due in the loan.
That's why 6 crore 90
Lordship.
lakhs is due.
Lordship.
And your case is that 5,80,000 as per the WhatsApp message of the bank
And 40,000.
And 40,000 you deposited.
Lordship.
And subsequently after depositing, they have raised the penal interest, other interest, 3 types of the interest
Lordship.
they have deducted from your account.
Lordship.
Okay. So now you tell me if as per their claim 6 crore 90 lakhs.
Lordship.
6 crore 90 lakhs, how much amount would be in your account which cannot be said that it cannot be NPA?
My lord, it will not be NPA if I am servicing the loan as per the requirements of the respondent bank. Let's say my final outstanding, total outstanding is 6 crores.
Yes.
My lord, the bank is supposed to tell me that this is X is the amount you are supposed to pay within that date. Within 29 June, you will pay 6 lakhs rupees. My bank account has to have 6 lakhs rupees. And in this case, lordship, I did have 6 lakhs rupees. And that was debited also. Now the point is, on the very next day, you deduct 15 lakhs or more. And that is where the declaration comes. Because lordship will kindly think from pure logic. Why did the NPA declaration and the 13-2 notice happen immediately after the debit of that penal interest?
Yes.
Has any logic been shown to your lordship as to why this penal interest was?
13-2 notice was issued.
My lord, the 13-2 notice on 7th August 2024.
7th August 2024.
Which is page 191. of volume 4.
Yes.
Now, my lord, what happens in the 13.2 notice? My lord, then this equation of the installment no longer applies. Then you recall that loan, entire loan, and then the provision 13.2 says, then you have to pay me that 6 crore. That is being shown to your lordship.
Yes.
But that illegal penal interest levy, which caused this in the first place, has not been addressed.
Yes.
Now, lordship, the second limb of the answer to that submission made by Mr. Mukherjee is that even if there was no penal interest, my due outstanding as per the installments I'm supposed to pay was not enough. Now, lordship, how will your lordship know whether that submission is correct or not? If there is a breakup of the amounts which have been deducted, breakup as to how it's been calculated, on what basis they have come. Now, that is one of my main grievances in the writ petition. That breakup has not been provided to me till date.
What breakup?
My lord, as to how, what is the calculation of what is due and payable? What is the calculation of penal interest? That has not been given to me till date. Okay. What was given to me, I showed your lordship. It simply says, as penal interest, X amount is charged. How? And that amount is apparently immaterial. It was still, I was in breach. How?
Okay.
Well, this is not, this is completely a powerful entity riding roughshod over a citizen's rights.
Okay.
I don't know how much, how you are calculating. I don't know how much I'm supposed to pay. You deduct and you say, even if I did not deduct the penal interest, it still would have been NPA. How? My lordship will take into account that this itself is mala fide. Okay. So, my lord, that is the principal submission. My lord, the other submission is with respect to the case cited by my learned senior friend. I'm not even dealing with that case. It's a division bench of the Telangana High Court, which says that NPA declaration cannot be challenged in writ petition. Now, my lord, there are, to my knowledge, at least 10 judgments of our court where NPA declaration has been set aside and writ has been issued by this honorable court.
The maintainability was challenged in the writ petition.
My lord, on all those
writ taken into consideration regarding maintainability.
Lordship, in
is the 10 or 12 cases,
lordship,
whether that point was raised in that
lordship,
application.
In each of these judgments, my lord, may I show any one? My lord, there are 10 judgments. I have relied on 3. Lordship will kindly take 2023 SCC Online Cal 2397.
Page number?
Malad, so give me the complete.
29?
Malad, 2023 SCC Online Cal
Correct.
2397 at paragraphs 24 to 26. Malad, the other two, lordship, may I just tell your lordship the citation, and I'll tell your lordship the point. 2023 SCC Online. This also, there's something wrong in the number. My lord, will kindly give me a second. Here you've mentioned 2397, here you've mentioned 2397. This is 24 to 26, this is 27 to 29. Same judgment. My lord, in 2397, lordship will kindly note paragraphs 24 to 29. The other judgment, lordship, is 2023 volume 3 BC 327 at paragraph
volume 3
BC 327 at paragraph 20. And lordship, I have also cited 2 judgments on the RBI circulars that they have statutory force. I'm not referring. Now, the point in all these cases were there was a violation of the in one of the RBI circulars, which led to a declaration of NPA and issuance of a 13.2 notice. In each of these cases, we challenged the illegal act, the violation of the circular 1, the second consequential act, which is declaration of NPA, and the third consequential act, which is the 13.2 notice. in each of these cases, the respondent bank, Malad, in this case, in fact, in the two judgments I cited, Lordship, they all concern South Indian Bank, the same bank. In all the two cases, they argued that NPA declaration and 13-2 notice cannot be challenged in writ jurisdiction. Malad, the Honorable Court, Lordship, answered this point very simply by saying the NPA and the 13-2 notice are consequential acts. The first statutory duty of the bank is to abide by the RBI circulars. They have to act in terms of a statute. The moment there is a violation of this statutory force bearing circulars, there is a breach on the part of the bank, even if it is a private bank, to act in terms of its statutory duty. That itself then becomes the ground to come before the writ court and ask for an issuance of writ. Lordship wants to see the paragraphs, Lordship?
Where is the judgment?
Lordship, we had given it in compilation, Lordship. Lordship will see that in the compilation is there. But where is my compilation?
When you given the compilation, I don't.
Malad, we had handed over, Lordship. Malad, my learned junior had handed up. The day we concluded, Lordship. With the cases annexed. Where is the
Yes, yes.
Lordship, paragraphs 24 to 29.
Yes.
And the other one, para 20. Same. And
in that you have taken a 27, 29, now 24.
Malad, 24 to 29.
No, in your written notes,
Lordship, 24 to 29. Malad, that's in light of Malad, the queries raised by your Lordship.
Okay.
And Malad, the other one is para 20. Also the same thing. And Lordship, I have not placed the other judgments because in both these judgments, all the Supreme Court judgments on this point, starting with Federal Bank, have been dealt with as to how a writ petition is maintainable. Because the idea is, Lordship, the concept is very simple. Malad, by issuing the NPA notice, thereafter the 13-2 and 13-4, what a bank tries to do is to take away a constitutional remedy from a party and relegate them to a tribunal. So, Lordship, what the court holds is that you can't render a writ remedy infructuous by deliberately violating the circular and then taking this step and then come and say, no, you can't come before the writ court, you must go before the tribunal. But that itself is malafide. Okay. That is why the writ has to be maintainable in the facts of this case. Lordship will kindly consider that.
Yes.
Now, Malad, this, as far as the judgments are concerned, this of our Honorable Court, Lordship will kindly ignore the decision of the Honorable Telangana High Court. Malad, the other part is the prayers. It was argued by my learned friend, Malad, before Mr. Mukherjee arrived, that if Lordship considers our prayer, our case is restricted to NPA declaration and 13-2 notice. Malad, that is not correct. My main prayer is prayer C at page 41 of the writ petition. That was the prayer which was not read out. At page 41, prayer C. Declaration that debit of rupees such and such from the bank accounts of the petitioners is not in terms of the second master circular and is arbitrary, unreasonable, capricious, unfair, unjust, illegal. Yes. The second master circular is defined in the writ petition. That is the circular on penal interest. So note these judgments cited of our Honorable Court, not distinguished, not dealt with. Malad, the issue as to penal interest, that it is barred, not dealt with. Okay. Now, Lordship, the next argument is, Malad, even assuming the levy of penal interest was inconsequential, even then, the very fact that a penal interest was imposed should render the action bad in terms of the RBI master circular. I've already placed the circular before, I will not go into that. Now, Lordship, very quickly, the other argument, Lordship will kindly for once peruse the division bench order in this case, Lordship. Malad, I'll place only one paragraph. Malad, that is in the supplementary affidavit, page 53.
Page 52.
53, Lordship. Paragraph 28 of the order, Lordship.
Yes.
it is made clear that the merits of the disputes involved in the writ petition have not been entered into at all by us, and all questions, including the legality of the steps taken under Section 13(4) of the 2002 Act by the respondent bank, are being kept open for being argued by the parties before the writ court. So therefore, Lordship, the issue as to the subsequent issuance of the 13(4) notice cannot render this writ petition infructuous, because the Honorable Division Bench has interfered and has permitted us to argue on that.
No, court has stated that
We can argue.
the division bench has not taken into consideration. This court can consider
Lordship,
whether
Lordship.
that he is not telling that the court whether the 13(2) is to be taken.
Lordship.
Even the division
13(4)
bench said that the appeal is not maintainable.
Lordship, but the
not a
interim order was
judgment.
passed. But the upshot is the interim order was passed on equitable considerations. A jurisdiction was exercised.
Okay.
Now, Lordship, here I will only give your Lordship the relevant dates. Why do I say that in any event, Lordship, if Lordship sets aside the action of the respondent bank, the 13(4) notice will fail automatically. But even then, Lordship, to satisfy that that is also an example of mala fide, Lordship will kindly note the 13(2) notice was issued on 7th August 2024. I received the 13(2) notice on 4th September 2024. Now, Lordship, I would get 60 days time to submit a representation. Then they would have to consider it in 15 days. And thereafter, after disposing of my 13(3)(a), they could pass a 13(4).
Correct.
Now, Lordship, I got my interim order on 7th October 2024. The date on which, Lordship, we got the interim order, 33 days had passed. Now, Lordship, the 13(2) notice is in respect of what?
So why you are arguing this point?
My lord, because the 13(4) notice has been issued in this case.
This court will find that the writ is to be dismissed automatically, the time will be extended.
Lordship, but I just want to show the mala fide of the bank, Lordship, because I've made out a case on arbitrariness and mala fide, that this is another example of that mala fide. And I'll take 10 seconds more. My lord, 33 days had passed. So when your Lordship did not extend the interim order on 6 January 2026, I still had 27 days left. But they issued the 13(4) notice the very next day.
Okay.
And I had filed that morning, I had filed my 13(3)(a) representation. Within a span of, I think, 1 hour, the 13(4) notice was issued. So that is also an example of mala fide. And Lordship, my last point is this.
Can the subsequent event which this court has not been extended the interim order and taken the steps, those subsequently you got the interim order from the division bench, will be taken as a mala fide in part of
the mala fide is in not giving me the 27 days after.
You argue the matter on merits, sir.
Malad, I've argued. Malad, I just wanted to point. Lordship,
time of the court.
Lordship, my last point is, the another example of mala fide is in the settlement terms. Malad, the property which is collateral, which they will take and sell off, is worth 5 crore, less than 5 crore. I was offering in settlement 6 crore 25. Malad, the act of the bank is in not granting me that liberty to pay off that 6 crore 25, but they want to go after my 5 crore property and recover less money. That itself is an example of mala fide, because why they want to do this? Because it's...
But you entered into the one-time settlement.
The one-time settlement...
You are agreed for that.
Malad, I agreed for that.
Once you are agreed, then you can say that it is a mala fide.
No, it's not. Malad, the mala fide is in...
Before this court also stated that you have taken the time, you will pay the amount.
Malad, this settlement...
Now at this stage, you can say that is a mala fide.
Malad, I mean to say mala fide because...
You refrain in your petitions not to go here and there.
Malad, I'm simply stating that I as bona fide...
Once you accepted the one-time settlement, you paid some amount or not paid some amount. Before this court, you stated that yes, within a week you will pay. Then the court has extended the interim order. Subsequently, it is found that you are not paid the interim amount. This court has not extended the interim order. So now you can argue that that is a mala fide.
Malad, may I put it differently? All that I'm trying to say is Lordship will see that the petitioner's conduct is bona fide. that this is not a settlement I accepted. I offered.
Let the same be left to this court to decide
Lordship,
whether you are
Lordship.
or
that-
the bank is the bona fide.
Lordship, these are my submissions, and Lordship will kindly yours till Monday to file the note. We'll file a short note on Monday. Mr. Mukherjee has already submitted yesterday. I'll submit it on Monday. Lordship may make it CAV. My only prayer is, Lordship, the order of the division bench is interim order is till 31st.
Why you not come with the return notes today?
My lord, because I got overnight to deal with Mr. Mukherjee's submissions. Mr. Mukherjee had a week's time after I finished my submissions. My lord, I am asking for 3 days. Mr. Mukherjee got 7 days. I am asking for 2 days only.
Now that he's in reply.
But I will only deal with the
Hearing concluded. Counsel for the petitioner prays for 2 days time to file written notes of argument. Police stop. Let police stop. Hearing concluded. No, hearing concluded. CAV. Police stop. Counsel for the petitioner prays for 2 days time to file written notes of argument. Let the matter appear on Monday. On 2nd February, under the heading to be mentioned for filing written notes of argument.
My lord, will kindly extend the interim order till Monday because it expires.
Interim order is extended till the final order is passed.
Grateful, my lord. Very grateful for giving us a very patient hearing.
But
next,
that doesn't mean, Lord, extension of time for filing the written notes by him.
My lord, I had submitted that I will take 2 days after
Come
Mr.
on, third.
Grateful, man.
Grateful.
This matter without petitioners in a fix. Because we have to discharge without the sovereign duty of election commission. We have been doing. But my service condition says that if I cannot fulfill the target, then I will be penalized. And because of election commission duty, I am away from my service discharge for more than 3 months. Only I want this security that discharging of election commission duty will not ultimately would not affect my service condition. That's simple thing.
10 days requisition.
3 months.
3 months.
Must be 3 days.
Not for all. Not for all.
Yeah, there are people also. No?
Where is the order
My
for
representation blood is at page 125.
Now, where is the order for deputy due to the election duty?
That is kindly come to page 82.
93, for example, one of the.
Well, I have been discharging election commission duty. I have not denied it. I cannot deny it. But now, let the Damocles sword of my employer will not fall on me.
Insurance company.
Yes. Well, I am a development officer.
For the days of requisition, of course, not. I can't stand in the.
So what? It is election work is over.
Persons have been given allotted days for the purpose of carrying out these activities. Not that all the employees had been.
How many petitions are here?
But this is the association of
association.
Yes.
So what is
few number of employees had been requisitioned for elected days.
110 employees from LIC was taken at. I am affected like it. Now the situation is no joju, no tosu. Neither I can deny nor I can support. This is the whole situation. I am losing my employees.
Not in fact,
only,
not this.
Only security will not that the constitutional authority should ensure that because of discharging my duties with the election commission, the period should not be counted against me for not having secured the business as targeted.
That's not for LIC to answer.
That's not for election commission.
Well, the whole situation is.
So what you are doing with your employee who is going for the election work?
Because there is a notification of the Election Commission of India that if there is any requirement, we have to abide by.
Correct.
Now suddenly they have taken 1,210 employees.
Correct.
Well, I am affected like anything.
Correct.
Well, I am a company with a business concern. I am customer-oriented organization. I am in the list of SEBI. I am losing like anything. This is the whole situation.
Might be, but your staffs, as per the direction of the election commission, you are deputing your staffs to the election work.
I have to do abide by.
Correct. So why their service condition? Why their service will be affected?
We are not saying anything, madam. We are not saying anything now.
Now.
You do one thing. You file both election commission. You both file a report. Then I'll pass a profit. That will be better.
That is better.
The only grievance of the petitioner in the present writ application that the members of the association of the petitioners are the employee of the insurance company, Life Insurance Corporation of India Limited. As per the direction of the Election Commission of India, comma, the members of the petitioners have been deployed for the election works time to time. The petitioners are apprehending that if the petitioners will go for the election work, comma, their service will be affected in the insurance company. Full stop. To adjudicate this issue, comma, an affidavit is required to be filed by the insurance company as well as the election commission. Let the affidavit be filed by, let the report be filed by an affidavit within a period of 2 weeks. 2 weeks after serving the copy to the learned counsel for the petitioner. The petitioner has liberty to take exception, if any, within a week thereafter. List the matter on 26th of February 2026 under the same heading. Yes. Under the heading urgent motion at the top. Affidavit of service. Next.
This is, my lord, the doctor's choice matter.
Yes.
My lord, before I address your lordship, my lord, on the merits of the matter, my lord, I think, my lord, there was some misunderstanding. My lord, I find, my lord, that your lordship's order by which your lordship, my lord, directed the report to be filed on the basis of the Delhi High Court judgment, my lord, that was passed on the 16th. Now, my lord, that, my lord, followed, my lord, a representation by, my lord, the authorities, the food safety authorities, that, my lord, they had already, my lord, issued a fresh, my lord, improvement notice. Now, my lord, your lordship did not consider the improvement notice on its merits. Your lordship did not go into the matter. Your lordship simply said file a report.
Huh?
Your lordship simply said file a report. My lord, recording the fact that they had, my lord, now, my lord, filed a new notice, improvement notice. Now, my lord, thereafter, that was on the 16th. The matter, but the writ petition was, my lord, thereafter prepared and affirmed on the 18th of December. On the 19th, the matter was mentioned before your lordship. My lord, we have the YouTube recording, but it is, my lord, a detailed mentioning. My lord, I had also, my lord, not recollected this. Detailed mentioning where your lordship inquired what is the matter about, inquired about the notice. My lord, made a comment as to what can be done now. My lord, all these things are there. My lord, it's a very detailed mentioning where, my lord, everything has been brought to your lordship's notice. My lord, I have it ready, but, my lord, if your lordship wants to see it, only then. My lord, thereafter, my lord, lordship directed the matter to appear on the 23rd. My lord, 23rd, the matter appeared in the list as item number 101. Matter was mentioned before lordship at 1 p.m. when your lordship, my lord, directed the matter to appear in the next day. My lord, next day, my lord, when the matter did not appear, my lord, in the position directed, your lordship, my lord, no, I'm sorry. On the 23rd, your lordship was pleased to pass an order. My lord, giving us leave to, my lord, mention the matter before the vacation bench. My lord, we, my lord, pointed out on the next day that, my lord, this will not serve the purpose because, my lord, unless your lordship gives us leave to move the vacation bench, my lord, we will not be entertained. So, my lord, on the next day, that is the last day before the vacation on the 24th, my lord, your lordship, my lord, matter was mentioned, your lordship directed publication of a supplementary list. That is published at, my lord, 12 p.m. and then your lordship makes that correction. So, my lord, here, my lord, the matter was mentioned, your lordship's attention was drawn, pointed out that, my lord, these new notices are the subject matter of challenge, pointed out your lordship had earlier passed an order, my lord, recording the fact that they had, my lord, now, my lord, amended the notices or withdrawn the notices and filed afresh, and that is where the matter proceeds. So, my lord, that is, my lord, the position, my lord. I needed to, my lord, just draw this to your lordship's attention. I, my lord, personally went through the YouTube, my lord, recording to show, my lord, as to whether, my lord, there was any, my lord, wrong impression that was given to court. My lord, with the greatest respect, I find that, my lord, very detailed mentioning is there, and your lordship has engaged in a conversation with the advocate mentioning the matter as to, my lord, what is the subject matter, etc., etc. My lord, be that as it may. Now, my lord, coming to the merits of the petition. Now, my lord, so far as the first petition is concerned, my lord, that is, my lord, my learned friend's writ petition, independent research. My lord, how independent research is, my lord, we do not know. My lord, I have reasons to believe that they're not independent at all. They're really acting at the behest of a competitor. But, my lord, my learned friends then, my lord, say that, my lord, we had made representations to the food safety authorities, and the food safety authorities had, even, my lord, notwithstanding our representation, my lord, not taken any action on our complaint. That was the subject matter of the first writ petition. Now, my lord, when the first writ petition came up for hearing before, my lord, Justice Bhattacharya, then, my lord, my learned friend said that yes, now they have, my lord, ultimately taken action. So, my lord, the learned single judge was pleased to record that, my lord, now that action has been taken, the cause of action has ceased to exist. However, considering what is the report, you will be at liberty to take whatever action you want to. My lord, that, my lord, leads to the filing of the second writ petition. In the second writ petition, my learned friends, my lord, say that no, you have ultimately given them a clean sheet saying that, my lord, they have issued a disclaimer. That is not good enough. Now, my lord, your lordship was considering that matter. It is, my lord, in the course of, my lord, hearing of that writ petition, the second writ petition, that, my lord, your lordship noticed, my lord, the Delhi High Court judgment, because one of the points that had been taken by the food safety authorities was the fact that, my lord, they have an independent trademark registration. Your lordship noticed the Delhi High Court judgment, said that, my lord, this is not something that is sacrosanct. My learned friends also cited before your lordship a judgment which saying that section 89 of the Food Safety Act is, my lord, a non-obstantive provision, and, my lord, it ultimately overrides other acts. That is what the Supreme Court has also said. Well, it is at that juncture, my lord, when your lordship made, my lord, these observations with regard to the Delhi High Court order, that on the next day, when, my lord, the food safety authorities were required to make their, my lord, submissions in response to, my learned friend's submissions, it is at that stage that, my lord, they came and said that we have issued a fresh notice. And that is why, my lord, your lordship passed that order, saying that yes, fresh notice filed, taken on record, file a report. Now, my lord, the report was filed on the next date, but, my lord, before that, my lord, we had to, of, my lord, necessity, my lord, challenge, my lord, the new improvement notice, because say that unless you stop using doctor's choice altogether, we shall have to, my lord, stop your business. That is the purport of the notice. So, my lord, that is the urgency which led us to approach your lordship with a prayer to, my lord, entertain the writ petition. My lord, it was on the eve of the vacations, your lordship's, my lord, business did not permit the matter to be taken. Now, my lord, so far as this is concerned, now, my lord, if your lordship will, my lord, take up item number 13, my lord, that is the more comprehensive matter now, because item number 12 has, my lord, for all practical purposes now become infructuous, because those notices, which were the subject matter of challenge, are no longer there. Now, my lord, your lordship will now have to consider, my lord, whether I have a case for which
notice is no longer there?
My lord, my writ petition,
Yes, that
my lord, had two limbs. My lord, one is, my lord, challenging the action taken report, my lord, which, my lord, had been, my lord, issued, because, my lord, the action taken report said we cannot do beyond this because there is a trademark. So, my lord, trademark law, my lord, is outside the purview. That was one ground.
Correct.
And second was, my lord, there was a subsequent representation of mine which had not been dealt with, my lord, which, my lord, we wanted, my lord, them to, my lord, deal with.
Correct.
I had cited, my lord, primarily two judgments before your lordship. My lord, one, my lord, of the Supreme Court, which says, my lord, the provisions of this act override, my lord, the laws, my lord, any other law. My lord, there is, my lord, a non-obstantive provision, my lord, in, my lord, the Food Safety Act. Then, my lord, we, my lord, cited a Delhi High Court judgment where the stand was, my lord, of the Food Safety Authority, that Trademark Act, my lord, cannot come in the way, my lord, of, my lord, Food Safety, my lord, Act. So, my lord, and, my lord, therefore, my lord, the stand here, my lord, was contrary. So, and I concluded my submissions. Your lordship wanted, my lord, the Food Safety Authority, my lord, to, my lord, come back and tell your lordship, my lord, how they can adopt, my lord, contrary stands. On that date, my lord, which is 15th, my lord, 16th of December, my lord, your lordship kindly has a look at, my lord, that order, my lord, of 16th of December, which was passed by your lordship. My lord, it's, my lord, page.
Well, let my learned friend then, my lord, argue his writ petition first, then I shall, my lord, argue.
No, I finished my writ petition.
No, my lord, my learned friend seems to, my lord,
no, I must quote the
my
order.
lord,
Mukherjee,
Every attempt is.
have you made them a party in this?
No.
Well, I have served him a copy.
No, no.
I have served him a copy.
Served, my lord, we have an application to be added as a party, my lord, in the, my lord, writ petition.
So what I propose to
Yes,
do, let you be added.
Very
and
well.
You file the affidavit in
Very well.
opposition, and you filed a reply. And in this case, you already the party.
Yes.
The first case, you already in.
But in the first matter, my lord, all affidavits are complete.
Affidavits completed. Let this affidavit. Yeah, let. So let the affidavit be filed and both the application will be taken.
Yes, yes, my lord,
That's
I
the
have no
matter.
problem.
Well, in the my lord, third writ petition, I'll call it the third writ petition. My lord, the Food Safety Authority has filed an affidavit, served us a copy. We did not have chance to file a reply. We'll file a reply to that also. And if Mr. Mukherjee files an affidavit in opposition, we'll file a reply there too also.
Correct, and both the application will be taken up for together.
Yes, ma'am.
Otherwise, then again.
No, it has to be taken up together.
Yes, my lord, and my lord, may I just make one submission? I'm not pressing today. My lord, the mere fact that I file an affidavit, my lord, should not be taken, my lord, to my lord, having my lord, to my lord, my client having given up the point that, my lord, there has been, my lord, deliberate suppression, my lord, of facts in the writ petition. My lord, I'll point that out, my lord.
That
in
is
the
your affidavit.
Yes, yes, my lord, my lord,
Tell
that's-
your
yes.
affidavit.
My lord, the interim order, my lord, is still tomorrow. My lord, that will have to be extended.
Yes.
I'm ready to answer you.
Yes.
No, no, my lord, your lordship, my lord, it's best, my lord, that we finish it once and for all.
So, you know, this is very interesting. This is very happy.
973. Who can cancel?
Actually, since we have time, I can participate.
Application for addition.
No,
It's two. Can one you filed in your application? Can one?
Yes, sir.
Extension.
Extension of interim.
Extension of interim.
Doesn't matter. My lord, I believe it's only for extension, my lord, because we've not been served.
No, it is only for
Naturally, we are not parties as yet.
It is only.
My lord, we'll serve them can 2, my lord, which is, my lord, our application to be added as a party.
Item number.
My lord,
Item-
extension, my lord, my objections can be recorded. Only the objections for the extension.
Item number 7. Which one? 12. Item number 12. It is fine that.
Not giving it to us.
Item number 12. It is fine from the record. The counsel for the petition already concluded the argument, but the respondents have to argue the matter. But in the meantime, the private respondent has filed another application being WPA 2973 of 2025.
Physical copy of
2025 challenging the order issued by the designated
My lord,
officer.
My lord, I have been told at this old age that, my lord, if I need a physical copy, I must pay for it of the writ petition.
Well, let it be, my lord.
No, no.
Well, let it be taken, my lord, in a lighter vein.
Not given.
No, physical copy.
Given
not
a soft
soft
copy, my
We'll
lord,
give
I'm
a physical
requesting,
copy.
my lord, a physical copy.
Of course, we'll give it. Of course, we will give it.
Okay. Designated officer within the Central Licensing Authority,
Yeah, the
SI, Eastern Region.
No, he should learn to behave himself.
In the
Thank you.
in WPA number 2973 of 2025, the writ petition has filed an application being Can 1 of 2025, praying for extension of the interim order dated 29th of December 2025. The writ petitioner in WPA 2141 of 2024 has filed an application being Can 2 of 2026, praying for addition of parties. Full stop. Learned counsel appearing for the authorities raised objection for extension of the interim order. Full stop. Learned counsel for the petition WPA number 29273 of 2025 raised no objection for addition of the party of the writ petitioner number WPA 20141 of 20. Accordingly, Can number 2 of 2026 is allowed. The The Independent
তোর
Research Ethics Society
তোর আগের নোটটাই যে এখানে
Kerala is added as respondent number.
Your respondent number, my lord.
কাট করতে আমাদের 7 we are respond number 7
না 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 তোমাদের রেটে আমি কত নম্বর হয়ে
Respondent number 5.
oh
5. Respondent number 5.
5
Respondent number 5. Police, the petition is directed to take appropriate steps to add the Independent Research Ethics Society as respondent number 5 and to amend the cost title of the writ petition and to serve the copy of the writ application along with the annexes to the added respondent.
my lord without prejudice my lord addition my lord because my lord they have really
My lord, only thing is, my lord,
There's no objection है ना उसमें बोले counsel for the petition WPA numbers mentioned submitted the applicant may be added as a party without prejudice the data and consent of the writ petition. ठीक है police let the amendment be carried out within a by
within the probably within a week
within a week after serving the copy to the London Consul for the added respondent. Police stop. Scan number 2 of 2026 disposed of. As regard can 1 of 2026 this
my lord, can 2 I have only one request, my lord. Kindly don't allow prayer A, say this will be considered after affidavits in the main petition.
Yes.
Because prayer A is asking for vacating of the interim order.
Police stop. As regard the vacating of dispose of
Prayer A, my lord, your lordship will not allow.
dispose of with regard to the prayer A. As regard the prayer B,
My lord, B is service of my lord
Prayer C.
petition and C and D are my lord to be impleted and my lord be given liberty to file an affidavit. With your lordships already.
but this application can be disposed of because my lord ultimately your lordship is your lordship will vacate the interim order naturally
as regard which prayer you prayed
My
for
lord, prayer A, my lord, I
B, C and D is
C,
allowed.
D, my lord, kindly,
C,
my lord.
D is
Prayer A, my lord, will
As regard prayer A,
that's up.
the same may be considered at the time of final hearing.
Copy fine.
I will hear at the time of final hearing of the
Correct.
application.
And my lord, the application
well,
can be
that is
disposed of.
this application is for naturally my lord if your lordship does not accept my submission lordship will vacate the interim order that is my lord
That's why I am not vacating. This will be at the time
yes
of final
that's right
hearing.
that's right
Yeah, बोला. Prayer B, C, D is allowed, and with regard to the prayer A will be considered at the time of final hearing of the writ applications. Can 2 is disposed. As regard can 1 of 2026 with regard to the extension of the interim order, though the authorities have raised the objection, but this court find that the petition is already enjoying the interim order and matter is pending before this court for adjudication. Accordingly, interim order is extended. Is extended till added बोला ना. How soon you will file affidavit in opposition? The added
2 weeks, my lord.
the added respondent is directed to file affidavit in opposition within 3 weeks or 2 weeks?
2 weeks, my lord.
Within 2 weeks. Reply by
my lord 2 weeks
2 weeks thereafter. Police stop. The interim order is extended till March में एक डेट दे दो हियरिंग का. 12 बजे नहीं है. दो डेट दे दो.
ওকে টাকা দিয়ে দিও টাকা চাইছে
11-12 मार्च फरवरी में नहीं है ना. 11th and 12th March 2026 at 12 p.m. as a specially fixed matter. 11th and 12th March at 12 p.m. as a specially fixed matter. Can 1 of are you recorded your objects? Can 1 is disposed.
11th and 12th March.
Extended till 13th of March 2026 or until further.
At 12:30. Grateful.
Fan बंद करो. Next.
Malu, I think on behalf of the petitioners, it is that matter where we have challenged the virus of the legal metrology, government approved test center rules 2013 and subsequent amendment which has been made to that rules. My lord, on the last occasion, my lord may recollect that my lord, my lord, Deputy Solicitor General sought time with regard to the CAN 3 which we have filed, in which we have incorporated
CAN 3.
CAN 3.
For what?
My lord, this is the another amendment which has been made to the 2013 rules. This amendment was made in 2025. My lord, the virus of the rules has been challenged in this particular petition. Even otherwise, my lord, without opposition, that cannot be dealt with. What I am into, my lord, with regard to the interim order. Why I am seeking this interim order today? Because, my lord, after 2013, when the rule was formulated, wherein government-approved test centers were only granted the liberty to verify, my lord, the standard of weights and measures, my lord.
Before my learned friend completes his argument, just one point, subject to whatever my learned senior friend says, my lord. My lord, here initially, my lord, I'm just cutting out the virus was challenged of the rules of 2013. During the pendency, there was no order of stay. During the pendency, the rule of 2023, 2013 have been supplanted by a subsequent rule which came into existence in October 2025. Now they took out an application for that interim order. Now, initially also no interim order was granted. Now they are wanting that interim order so that that rule of 2025 may be stayed. Now, what I'm humbly submitting, I have got written instructions, but I would want to intend to file an affidavit because since interim order is there, the reason is this, that the rule has been implemented, rightly, wrongly, indifferently, because there was no stay. Now, my lord, the rule, and it has been acted upon by the stakeholders. Now, my lord, if a rule is stayed, it will render the act non-workable. So what I'm humbly submitting before your lordships, if my lord intends to take up the entire application on exchange of affidavits, my lord, then my lord can decide the virus once and for all. Because, my lord, this matter has been pending, my lord, since 2025, my lord. If we exchange affidavit or otherwise, my lord will have to hear out the interim application now on affidavit, and then my lord may decide stay. But, my lord, I would intend to file an affidavit because last time my lord intended to me to get instructions, which I have got. These are the salient points which I have put before your lordship. Now, my lord,
amended rule has been given effect to.
Yes, my lord, it has been given. If stakeholders have acted upon.
When?
My lord, because it has come into existence in October.
October 25.
Now this November, this application was filed. Now we are in January. We have already given. This is what the instructions are.
Rules have been enacted, but this has not been implemented in the sense that it has to be implemented by every state, including the state of West Bengal. But it is for the state of West Bengal that the government-approved test centers have to now take steps. But this requires an elaborate exercise to be conducted. But it's not that the rules have been given effect to in that practical sense of the term. But the rules have been enforced, which are under challenge. I'm not with. The question is with regard to the competence of the state, the central government to enact these rules in so far as the respective states are concerned. Not I am concerned with my state. In so far as the government-approved test centers are concerned. But my question is that it suffers from legislative incompetence. That's the sole question of law which your lordships will have to decide. That may not require call for any affidavits. That is only an interplay of two entries in the list, two lists. One is list 1, the other being list 2. Vis-a-vis list 3. Which one is general and which one is special with regard to a particular provision in the Principal Act. That's my sole point, which I shall be flagging as an issue before this honorable court.
So it can be taken up for hearing final.
Yes,
my lord, I being the representative of Union of India. My lord, I being the representative of Union of India, we always have to be backed by written instructions, that also on form of a report or an affidavit. So my learned senior friend is very much right that a point of law can be agitated without any affidavits because that is blatantly there in the books. But, my lord, my understanding is that, my lord, a short report or an affidavit, I may be directed to file with regard to the main application. Let it be on record so that whatever submissions are placed
may I submit
before
this
you.
to cut short the matter? The learned DSG wants to use an affidavit. I can't stand in the way. Not it's for him also. Not.
বুঝতে পারছো তো? My learned senior friend understands. I'm a creature of instructions from my client and direction from my lord.
How soon you will file?
My lord, whatever.
That's the question.
No, my lord, but I will file, my lord, because I am my lord's officer first. So I will take all necessary steps so that as soon as possible, my lord,
How
we
soon
will
you will
file.
file? That's why then I will fix a date.
Kindly give us liberty to approach your lordship's court in the event not this is being sought to be implemented.
My lord, it has been implemented because my instruction, my lord, my instructions are that it has been implemented. Now, whether in West Bengal or not,
That's why you file the report. How soon you will file? Within
my
3
lord, with
weeks?
regard to my lord will
Within 2
kindly,
weeks?
my lord, if my lord intends me to file a report with regard to CAN 3
No. Writ application on merit.
on merit, then my lord, in that particular case, my lord will at least give us 3 weeks time, my lord, we can come back.
Because you file the report in the original writ application.
No, my lord, we have not
You
filed.
file the report by
My
way
lord,
of an
report,
affidavit.
let it be an affidavit in opposition, my lord,
So
proper.
how soon you will file?
My lord, 3 weeks to 4 weeks, my lord, whatever falls, my lord, from my lord. Because my lord, it is
That several provisions of the act will become unworkable if it is practically sought to be implemented. Not this gives a not the effect of the rules is it will have an impact on the parts of a machine.
Correct.
With the machine being not controlled by the state.
So let you file by 20th February.
20th February.
Today we are on last. 20 days you will get. 3 weeks. 20 February and you file reply by 2nd March or 5th March. 5th March. Then I will fix the date for hearing. It is found from the record the petitioners have challenged the virus of the rules. Thus, this writ application is to be decided only upon exchange of affidavit. Let the affidavit in opposition be filed by 20th February 2026 after serving the copy to the learned counsel for the petitioner. The 20th February 2026 after serving the copy to the learned counsel for the petitioner. Reply, if any, be filed by 5th of February 2026.
March.
List the matter on. Give the date. March date আছে কি? দেও 12 কবে? 16th March 2026 at 12 noon.
I'm grateful.
But I was only seeking liberty not to approach in the event not it is
It is made clear that as this court has not taken up a hearing with regard to the civil application wherein the petitioner has prayed for an interim order, but the petitioner is liberty to mention the matter as and when occasion arises.
As in, my lord, liberty to mention, my lord?
As and when occasion arises.
I'm grateful. I'm grateful.
জানি না 15 কি হলো My lord, is very unfortunate state of affairs. I am very sorry to say this. This is the 3rd time I am coming and the matter is being listed that the file is not here. My learned advocate's clerk had gone to the department and it has been reported that the file has been sent in this court on 7th of November. My lord, I tell you the reason. The main appeal not কি আছে? Main application was appearing for hearing since November 2005, and matter could not appear in the list unless the file is here.
Item number 15.
My lord, kindly give a strong direction, my lord, so that the matter is taken up in the next week. Irrespective of the result of the matter, but the matter has to be there. Every day it is being done.
ডিপার্টমেন্ট
Tell
থেকে
the
আমি গেছিলাম
department
ফাইল এখানে
to be
এসেছে
present
7th
in my chamber at 4th.
আমি yesterday I went there
With all what are the no file you mentioned here with report at 4:30 be in my chamber.
So may I take it the matter may come on the Monday?
But it will come.
But it will remain in the list.
Now I made up mind. I will come at 4:30. I will sit here and I will see how the matter cannot be.
I'm very sorry to say all.
No, not you. Since morning, this is a fifth matter. What can be done? Now I will come at 4:30 here after the court. Then I will sit and I will see how the matter can be taken. That only can I do.
Lordship has to take that extra burden.
Because I have informed the RG, I have informed the deputy, I have informed the joint.
Even then, no, nothing has been done.
Nothing has been done.
Very unfortunate.
Now I have to do the labor work here.
Would it be Tuesday instead of Monday?
Well, he has some personal
Some
difficulty.
personal difficulty.
Let it become Monday. Mention I will take on Tuesday. No problem. Let the file search it out. Next.
I am appearing in this matter on behalf of the petitioner. In this matter,
Immediately inform the department, whatever not file mentioned in this today's list, take the report and come at 4:30 in my chamber. And if they will not come at 4:30, once 4:30 might watch, then they have to face the consequence. Yes.
in this matter, Lordship, at the outset, I would like to draw the kind of attention that
Item numbers?
16.
16. File not here.
File has been found now.
Yes, yes.
And correspondent is not here, so I think it would be in the interest of justice.
What is the matter?
That a premature release.
Acha.
And I have made a written notes in order to assist the court.
Okay, in keeping the written notes, I am fixing a date. Next date. Next.
Especially fixed.
And you inform the other side.
Yes, yes. Especially fixed lots.
The none appears on so-and-so appearing for the petitioner and file the written notes. Let the same be kept with the record. As none appears on behalf of the state for the interest of justice, the case is adjourned. Let the matter appear on 10th of February 2020.
Especially fixed lots.
At the top. टॉप में है कोई देखो 10 फरवरी टॉप में तो नहीं है at the top under the heading urgent motion. Petition director to inform the next date of hearing to the state.
I will inform. Briefly of language.
Next.
I appear for the writ petitioner. But in this case,
17 also, my lord, file
not there. Please.
Item 18, I appear for the writ petitioner. My lord,
Yes,
in this case, my lord, what happened, my lord? The Security Exchange Board of India, my lord, initiated a recovery proceedings, my lord, against a big company, my lord, who was the borrower. Now, my lord, a public auction was held. My client, my lord, deposited the entire sum of money. Sales certificate was issued. Now, my lord, one person, my lord, the one villager, is claiming a possession, my lord, that in respect of a particular land, my lord, and mentioning a certain area. Now, my lord, the Supreme Court and the High Court, your Lordship's Court says, once the sales certificate is issued, public auction is held, my lord, it is incumbent upon the police authorities and the SEBI to my lord, deliver the possession. Now, that is the law, my lord. I, my lord, first of all, the SEBI is here, my lord. You are SEBI.
Yes.
SEBI is here. And my lord, the state, my lord, may I take my lord's kind attention?
Yes, you are appearing.
I am appearing for SEBI, my lord.
What is your instruction? What is your instruction?
My lord, in this matter, the sale was confirmed on 28th September 2023. Pursuant to the sale certificate that was issued, SEBI had written to various authorities, the Inspector General Registration, including the District Magistrate and Additional District Magistrate, in 2023 and also in 2025, to provide assistance to the petitioner to hand over the physical possession of the property. The property is, my lord, a vacant land at Nodia. There is a discrepancy with regard to an illegal occupant in a portion of the land. SEBI had, in their letter to the DM and ADM, had written to them to provide assistance to the petitioner. In this, my lord, my only submission is that SEBI has taken their requisite steps.
What about you, state?
My instruction is concerned, my lord, we'll take appropriate steps if my lord directs. We'll take appropriate steps.
Takes only one steps. Calling the concerned SP and then before this court, and will take an undertaking which date he will hand over. That is the only step this court can pass upon. Nothing else.
Take some time, my lord. I'll come and
That's why
refresh, my lord.
you give the suggestion, you will take appropriate step of holding possession. Otherwise, by that day, you will not give the possession, then
My
the
lord,
officer concern of the
Give them, I have waited so long, give them 15 days time because
concern
yes,
date,
15 days time in the
concern
event they
date,
don't.
I am fixing by
But
that
you-
you give
my
the
lord,
possession.
some
If you
authorized.
not give the possession by the concern date, then the concern
Yes.
SP
My
and
lord,
the officer in charge
I'm
of the
extremely
concerned
grateful.
police station
my
appear
lord,
before this court
unauthorized occupancy is there, my lord. We will take
with the affidavit.
we'll take appropriate steps for removal.
Appropriate steps a vague word.
Since 2023,
Lordship,
not 26. And the SEBI is requesting you.
lordship, yes, my lord. Kindly,
You have,
lordship, I'll come with instruction, my lord. Latest positions.
affidavit that you have handed over the possession.
Millard, kindly, Millard, give him some handle, Millard, so that he can communicate your lordship's mind, Millard, in a way. Otherwise, Millard, the authority will maintain angelic silence, Millard, and will do nothing.
You have
This,
taken the
Millard,
money
we are
from the
acquainted with this executive inertia, Millard.
taken the money from the person. SEBI is requesting you to give proper protection so that they can execute the order. But you are silent over this.
DM is also silent. The SP silent. Officer in charge, Millard. Kindly, Millard, record your lordship's dissatisfaction to the extent as it's possible under the law, Millard, so that the SP, Millard. Millard, does your lordship need the judgment, Millard, which your lordship courts passed? Unreported judgment, Millard. They were there a copy there. And then I will refer the Supreme Court also.
Why you persons are not taking proper instructions from the
Millard, in this case, kindly comes to Millard the third page. Learned counsel for the SEBI places reliance on the documents annexed to the writ petition to argue that SEBI has duly taken steps before the appropriate authorities for the purpose of getting help to have the property demarcated to ensure that the possession handed over to the petitioner becomes effective. A perusal of section 28A, subsection 2 of the SEBI Act clearly shows that the recovery officer shall be empowered to seek assistance of the local.
district
Yes,
administration.
administration while exercising the powers under such and such. Section 28A, 1 of the SEBI Act pertains to recovery of amounts inter alia by the modes of attachment and sale of the immovable property of the accused person. In the instant case, there is no doubt as to the petitioner being the holders of a sale certificate, which shows that a valid sale already has been effected in favor of the petitioner. However, the inaction on the part of the respondent, such and such, with regard to rendering assistance for the purpose of exercising the powers under such and such SEBI Act by the RO is required to be deprecated. Since the state respondent chooses to remain unrepresented when the matter is called on for hearing, no further notice is being directed. In view of such and such, directing the respondent 2 to 4 make necessary as much, including provide a registered Amin of the state to carry out the demarcation of the property. Today, Millard, this slight change is required because the recovery proceeding indicates, Millard, the extent of the land. So I'm entitled, Millard, I have given 4 crores. So, Millard, I'm entitled to the entire land. Correct. Whoever is in illegal occupation of the property, he cannot have any right. And in our case, Millard, the demarcation has been made. It was found in illegal occupation, page 102. In order to, Millard, eradicate any confusion or the cloud, Millard, even if it has shrouded the mind of the Honorable Judge, Millard, I take my Lord's kind attention to page 102. And I will show, Millard, this is not by accident but by design. The callous executive inertia, Millard, creates an inroad into the judicial proceeding. Kindly seize the page 102. Out of the total, may I take my Lord's kind attention to read for my Lord, page 102, Millard, paragraph 2. Out of the total 0.782 acres of the property of the 2 plots such and such, acres from the plot number such and such, acres from the plot number such and such, in a peaceful possession of such and such, Maji Mali Agro Limited, that is my client, and remaining such and such acres from plot number such and such plot number of the land from the two plots in possession of another person, namely Ajay Shah, for which a notice was issued to such and such, but he could not show any valid document and proper deed about his right title in respect. So why he should remain? I put this question. Why the state is giving indulgence?
Where is the sale certificate?
Sale certificate, my lord.
Page number 78.
Page 78. I'm sorry, my lord, for being late. 78. Now, kindly see, my lord, if I may permit to say, my lord, that to take my lord's attention to page 81, the SEBI had, my lord, categorically said that SEBI had issued a sale certificate of sale dated September 8, 28, 2023 under such and such second schedule to the income tax rule with read with section 28A capital such and such to the aforesaid buyer in respect of the property mentioned against their name. In view of the same, the registering office has been requested to take note of the same and proceed with the filing of sale certificate in book number 1 maintained by their office when the aforesaid buyer comes for payment of stamp duty. So government will earn revenue, state government. The registration authorities must be proactive for this.
It is registered or not?
Sales certificate, then the next step is payment of stamp duty. Sales certificate was given, 78.
Correct.
Now, that has to be registered. The conveyance, I am to give stamp duty and registration fee.
No, that is registered or not? Have you paid the?
No, no, nothing. Sales certificate was given, but the registering authority, he is representing. The Inspector General of Registration must come in aid of this petitioner. I have deposited 4 crores. I want to set up an industry in the state, my lord. Hospital. Police is inactive, my lord. The administration is inactive, and this is a calculated silence.
Yes.
But may I take my lord's kind leave? Another matter. I am deadly obliged.
Yes. Okay. The petitioner has filed the present writ application being agreed with the action of the authorities that in spite of grant of sale certificate by the SEBI on an auction proceeding with respect of the land within bracket area 80.5 decimal at RS Khatian number 4092, LR Khatian number 2116, 2117, 2119, 2097, 3736, 5382. RS plot number 4317 by 6781, LR plot number 8629, 8630, JL number 155 Moza, Ranaghat under PS Ranaghat district Nadia, West Bengal, the district administration is not handing over the possession of the said property to the petitioner. The Land Council appearing for the SEBI authorities, SEBI submits that SEBI has made several requests to the local administration for making necessary arrangement for handing over the possession of the said property to the petitioner, but till date, in spite of till date, the request made by the SEBI has not been considered. Full stop. Land Council for the petition had drawn the attention of this court to the demarcation report issued by the Revenue Inspector Ranaghat Municipality, Ranaghat-1 Nadia, wherein it is found that out of total 0.7842 acres property from the 2 plots 0.7099 acres within bracket 0.7004 acres from plot number 8630 and 0.0095 acres from plot number 8629 is in peaceful possession of the petitioner, and the remaining 0.0743 acres within bracket 0.0138 acres from plot number 8630 and 0.0605 acres from plot number 8629 out of land from the two plots is in possession of another person, namely Ajay Shaha, for which a notice was issued to Ajay Shaha as per the rules, but he could not show any valid document or proper or paper or deed about his right title in respect of 0.0743 acres of the property from the said plots. Full stop. Learned counsel for the state pressed for a week time to take instruction and to file report before this court. Accordingly, for the interest of justice, the state is directed to file report by way of an affidavit indicating that why, in spite of several representation made by the petitioner as well as the SEBI, the land has not been, the possession of the land has not been handed over to the petitioner. This court direct the state authority to take appropriate steps for handing over the said property to the petitioner and to file the report on or before 18th of February 2026. Reach the matter on 18th February 2026 under the same heading. The petition is directed to communicate this order to the district administration of Nadia district as well as the police authorities. Yes, I have fixed the date. I have fixed the date. If you want the name, उसका एक काम कर दो, उसका नाम कर दो, ये प्लेट for time करके कर दो. Yes, next.
I appear for the petitioner,
Yes.
item number 19.
19.
The railways were supposed to take instruction. Item number.
Lordship, they were to take instructions, Your Lordship.
Yes.
On the last occasion, Your Lordship, they were to take instructions with regard to the requirement of the goods that the petitioner was supposed to supply to them, Your Lordship.
Liquidated damage imposed upon the landlord, consequent punishment paid for time to yes. What time? Yes, Mr. Dasgupta.
Your Lordship, my interim order is expiring on 3rd of February, Your Lordship. That may be extended.
The Learned Counsel appearing for the Union of India press for further time to take instruction. Accordingly, case is adjourned. Let the matter appear on 11th of February 2026 under the same heading. Interim order is extended till 13th of February 2026 or until further order, whichever is appear.
Grateful. Grateful.
Well, I'm appearing for the petitioner. Well, in this matter, one person is doing 2 government jobs.
Yes.
And your lordship has a copy.
Yes, what is the report? He's working in 2 places. What explains why the criminal case has not been initiated? If a person has made impersonation, why the criminal case is not why the criminal case has not been initiated?
Well, a copy of the report.
And that too in the police department as a volunteer and working in the block development. So why once he is working in your department as a civil voluntary, and he came to know, your authority came to know he is working in two places, why the impersonal case has not been initiated against him? Because he is working in the police department. So that's why you are not initiated the case.
No, Your Lordship.
Can I call the
Give him
SP
a
here?
chance to explain. If he is not giving the explanation, we will take appropriate.
What explain? What is the madam? This is a criminal case. Once you find that he has taken the two benefit from the two department and working in two department, then you want.
Lordship, may I submit? May I submit on behalf of the respondent number 6, Lordship? This is the contractual basis job and no work, no pay policy regarding, and he civic as a civic volunteer, he is working on night shift.
Which you adopt, I will pass an appropriate order. He will.
No,
he will submit.
Leave to file affidavit and opposition regarding the.
If you're telling that you will surrendering one post, then I am passing here an order. Otherwise, I am passing an order to register an FIR, investigate the matter, file the report before this court.
To file affidavit in opposition.
I will not.
There are so many disputed fact.
Maybe.
Question of fact. It is not relying under Article 226, Lordship. Several judgment by this.
That you challenge in appeal.
Lordship, my humble submission is that we will file affidavit in opposition. Then whatever your Lordship. Affidavit in opposition. Kindly leave to file affidavit in opposition.
In the meantime,
And the allegation regarding.
In the meantime, he will be stopped to do at least one work. He's doing nothing. In nowhere he is working, it seems. A single person, how can work as a civic volunteer on one hand, on the other, data entry operator, where the data entry operator's work is scheduled from 10:30 to 4:30. It is scheduled data entry. Fixed time is there for the work of data. And state is indulging in.
Your Lordship, we have came to know about this recently.
দুটো রিপোর্টের কপি লাগে আরেকটা আমার
So civic volunteers working as a civic volunteers in your department. So there will be a GT entry maintaining by you with regard to the attendance.
Yes, sir.
Which period to which period?
Your Lordship.
What is the time of the
He serves at the night duty.
night duty?
Night duty, sir.
আমাকে দিয়ে দিবেন নাইট শিফট read petition is itself is not maintainable, Lordship. Yes.
I will see. Whether read petition is not maintainable or your service is not maintainable.
Obliged, Lordship.
The court will see. Because of this, you persons are allowing this the two numbers persons in the society. That's why the unemployment is growing up. One person has been debarred for your illegal activities. If you could not been applied for the
there is
data
a
entry operator,
Lordship, there is a
person could have
delay.
been.
More surprisingly, in bank account, there are two bank accounts, it seems.
Private respondent engagement as data entry operator dates back to year of 2020, Lordship.
Must be there.
And petitioner
two
applied
other
2022, 2 years late.
Two other cards, two
Delay and
voter
lectures are
cards.
there. Delay and lectures are there, Lordship. My humble submission is there.
এই করছো কেন বিষয়টা? You are complicating the matter.
একটা আমাকে দিয়ে দেন
Two other cards are
একটা
there.
কপি
They must
রিপোর্টে না ওনাকে দিয়েছে স্টেট কে না ওই দুটো আছে নাকি এখানে না রিপোর্টে একটা আছে
আমার কাছে
তাহলে এটা পিডিএফ স্ক্যান করুন
By an order dated 6th of January 2026, this court has directed the Superintendent of Police, Baraipur Police District, to ascertain whether the respondent number 6, namely Khokon Pandya, is the same person being name of Usman Pandya, who is working as data entry operator in Canning 2 BDO office as well as a civic volunteers in the Jikantala police station. On receipt, police stop. In compliance of the order passed by this court, comma, the Superintendent of Police, Baraipur Police District, has submitted the report. Dated 27th of January 2026, wherein it reveals that during inquiry, Usman Pandya transferred his name to Kokan Pandya in various government departments, that is birth certificate, Aadhaar card, voter card, PAN card, ration card, passport, bank account, driving license, etc. Further, it was revealed that two EPIC, that is ZUB 1926260 and ZUB 1422179, further revealed that he is having two EPIC number. On further inquiry, it was found that one EPIC number in the name of Kokan Pandya is active, and the other EPIC number in the name of Usman Pandya has been removed from the voter list. This is in connection with the Jibantala PS GDE number 1055 dated 24 July 2025. The report further reveals that Kokan Pandya is the same person being the name as Usman Pandya, who is working as a data entry operator in Canning 2 BDO office as well as civic volunteers in the Jibantala police station. The learned counsel for the state submit that when the authority came to know about the said offence committed by the petitioner by the private respondent, a notice has been issued to the private respondent calling upon him to explain regarding working and drawing salary from the department to explanation regarding working and drawing salary from a department organization, even he is full-time employee in the Jivantala police station as a civic volunteers at the same time. This court failed to appreciate once the police authorities have came to know that the person has committed a crime, but instead of the same, no action has been taken by registration of the case and investigating the matter. But on a simplest way has issued a notice for calling for explanation, which this court which is not acceptable from the police department. Accordingly, the Superintendent of Police, Baraipur Police District is directed to take appropriate action against the private respondent. It is further directed that the service of the private respondent is restrained from holding any
Lordship,
the authorities, that is the Superintendent of Police
and PDO,
Baraipur Police District, as well as PDO Canning 2 is directed not to allow the petitioner to perform his duty as he has misrepresented before the department and working in two departments. The private respondent, the learned advocate appearing for the private respondent prays for time to file affidavit. Let affidavit in opposition be filed within 3 weeks. Reply, if any, will be filed within a week thereafter. On the next date week, the authorities are directed to file a report with regard to the action taken. File action taken report before this court. list the matter on 25th of February 2026 under the same heading.
March of like.
Lordship,
Report
no adverse
with the report.
order should be passed, Lordship, because without listening, without being filed affidavit in opposition, how can it be ordered, Lordship? There are several explanations. Why are you interfering me? I'm defending my client. Lordship, kindly consider, Lordship, after affidavit in opposition, you will decide anything, Lordship.
You are before the wrong court.
Lordship, kindly, Lordship, it is my humble submission.
I have given the chance to file report, no problem.
But you are passing adverse order, Lordship.
Again, I pass an order for deposit all the money.
No, Lordship.
With the two posts.
My humble submission is only that.
It's an order to deposit whatever the amount you have received from board department. Can I pass an order?
There are explanations, Lordship. No, Lordship. No, Lordship.
After the order
No, Lordship.
by this
Kindly,
council
Lordship.
appearing for the private respondent.
No,
says
Lordship.
that this court has passed an order without giving an opportunity of hearing. Full stop. This court find that when the matter is called, the private respondent and advocate appearing for the private respondent is appearing before this court and made a submission.
It is apology, Lordship. Kindly apologize.
Accordingly, the private
Lordship, kindly, Lordship. Don't, Lordship. It will harm to my client, Lordship. Kindly, Lordship. I'm praying. Kindly, Lordship. Obliged.
There is a demand of the court. You must maintain it.
Okay. Obliged, Lordship.
Manner you were talking. No. Manner of
Next.
Lordship, item number 23. I am on behalf of the petitioner, Lordship. With your Lordship's permission.
My Lord, I am for State Bank of India.
I am filing.
My Lord, I have received copy of the petition yesterday only.
What is the prayer? What is the prayer?
Lordship, the crux of the grievance of the petitioner is that, Lordship, petitioner applied for personal loan from state before the State Bank of India for rupees 9,28,000. And Lordship, this application was allowed, but Lordship at 9,28,000. Yes, 9,28,000. And this application was allowed, and after that, only 7,28,000 was disbursed in the account of the petitioner instead of 9,28,000, Lordship. So, Lordship, for the purpose of this due.
What total amount your loan? 9 lakh.
9,28,000.
Correct.
I have
how much you have paid?
Lordship.
How much you have paid? You have paid the loan amount?
No, actually, Lordship, I have taken this loan amount.
Correct. So what has happened now?
Only 7,28,000 has been disbursed in my account. 2 lakhs has not been disbursed.
When the loan amount was sanctioned?
Lordship, I humbly draw your Lordship's kind attention on page number 12. The date is, Lordship.
When the loan was sanctioned? 9,28,000.
Mentioned.
8 March 2025.
Lordship.
We hereby sanction the loan amount of rupees 9,28,000.
9,28,000.
Correct. Then what has happened?
Only all of
the payment schedule
against 9,28,000, only 7,28,000 has been credited in my account. Lordship.
Correct. Then
2 lakh has not been amount of 2 lakh has not been.
Your EMI is 15,793.
Lordship.
EMI is for 15,793.
793.
Correct. Then what has happened? But Lordship, they have paid only 7 lakh. 28,000.
7,28,000.
2 lakh has not been paid.
No, Lordship.
But they are taking the interest of the total amount.
Lordship. I am paying the interest, Lordship.
My Lord, in this matter, Mr. Devashisha is appearing for State Bank. I have received copy of the petition yesterday only. I will need to communicate with the bank and.
Why? File the report. Well, how soon you will file the report? Why you are not disbursed the other 2 lakhs, and why you are taking the interest of total 9,28,000? This is your grievances.
Lordship, this is my grievances, Lordship.
My Lord, I will require some time to take instructions.
Tell your bank.
Very well.
Report is very harsh.
Yes, my Lord.
The grievance of the petitioner before this in the present application is that on 8th of March 2025, the State Bank of India, Pakpara branch, has sanctioned an amount of rupees 9,28,000 with the 98,000, but the bank has only paid an amount of 7 lakh, and further 2 lakh has not been disbursed in the account of the petitioner. It is further contention of the petitioner that the bank has only paid 7 lakh rupees, but is charging the EMI of rupees 15,793 of total amount of rupees 9,28,000. Police. Learned counsel appearing for the bank press submit that he has received the brief only yesterday and pressed for time. Accordingly, the bank is directed to file a report by way of an affidavit within 2 weeks.
Yes, my lord. 2
weeks, list the matter on 17th February 2026.
Lordship, may I take one indulgence, Lordship? 17th, I have LLM exam, Lordship. So after 17th, Lordship.
19th? 19th February,
And-
under the same heading.
And Lordship, one thing, Lordship asked me the date of sanction. But Lordship, 18 March 2025 is not the date of sanction. It is the date of my application. But date of sanction has not been mentioned in any document, Lordship. Date of application is 18th March 2025, Lordship.
Because kindly come to the page 15. Page 15, your EMI started from 1st of April.
Lordship.
Correct. Affidavit of service be kept with the record under the same heading. Under the same heading. Next.
In this matter, I appear on behalf of the petitioner. So, my lord, there was a direction passed by still my lord Justice Amrita Sinha to file a report with regard to admitted amount which has been kept my lord, withheld by the authority concerned. So now, after passing your lordship's order, considering that their order which has been passed by my lord Justice Amrita Sinha, they have not complied. Then matter was came up before your lordship. So now your lordship again directed to the concerned jurisdictional BDO to file a report. So now after my lord passing your lordship's order, I have been communicated the my lord the affidavit as well as the my lord the report which has been my lord this BDO wrote to the my lord the district magistrate.
What is the prayer?
My admitted amount has to be paid by the authority concerned pursuant to the work order which has been issued in my lord 21st of September 2020. So kindly come to page 9.
Correct.
Then I have completed the work.
When you completed the work?
In 2020.
Correct. Then
the authority concern has come with the plea that the fund is not available.
Where is that?
Mala, they have when petitioner went to the office of the. Then I moved a petition before the my lord Justice Amrita Sinha. The lordship directed to file a report. So now they did not file a report. Then matter came up before your lordship. Then again your lordship directed to file a report. So now after that I have come to know.
I am happy to be of the state, my lord. I bring not today as senior is absent, my lord.
Who?
My panel lawyer is absent today.
What is the report you got?
My lord, this I got my claim was 1,76,000. So
the report is with me, my lord.
The order which has been passed by the same block, same work order, my lord, is a case. My claim 1,76,000. They have admitted 1,73,000.
This. My lord, this is my report, my affidavit, in the form of affidavit. Correct, my lord.
What you have prayed for?
The last paragraph, my lord, serial number 10, my lord, possibly.
It will clear the entire bill amount if found eligible after fund as soon as practicable.
My lord, this is the order passed by your lordships. The same block, same work order. My lord,
I am disposing of.
My lord, there is a along with the my lord, the interest, your lordship the same. Considering the earlier judgment passed by my Lord Justice Divas Pattonayak and your lordships has extended the interest part. Well, this judgment, my Lord, lordship's judgment, my Lord.
The petitioner has filed the present application for a direction upon the respondent authorities for release of the admitted amount of rupees 1,73,700, being the amount uh, 73,000. Foolish. Counsel for the petitioner submit that on 1st of September 2020, the block development officer Mathurapur -2 development block South 24 Pargana had issued the work order for reconstruction of Kailashpur FP in Nandakumarpur GP under the Mathurapur Roman 2 block under the fund of the BCW serial number 37. On receipt of the work order, the petitioner has completed the work and has submitted his will. But in spite of completion of the work and submission of the bill, the respondent authorities have not paid the said amount. Subsequently, the petitioner has made several representations, but the authorities have not considered the same. This court, by an order dated 15th of September 2025, directed the block development officer to file a report by an affidavit. In terms of the said order, the block development officer is the block development officer. Who is he?
Well, the block development officer Mathurapur 2.
No. Who has filed this affidavit?
Well, he's authorized person.
The assistant, technical assistant within bracket. Okay. Manrega at Mathurapur 2 development block has filed a report by way of an affidavit stating that pursuant to the work order of the block development officer, the petitioner has completed the work with the satisfactory for a total amount of rupees 1,73,180. It is further submitted that the block development officer has already requested the district magistrate South 24 Pargana for making necessary arrangement for release of fund so as to enable the block development officer to release the said amount in favor of the petitioner. The petitioner has handed over a communication dated 19/11/2025 issued by the block development officer to the district magistrate, wherein it is admitted that the petitioner has executed the work for a total sum of rupees 1,73,182. But the payment could not be made due to non-availability of the concerned record. Now the authority have traced out the records and found that the petitioner has completed the work. Full stop. Consider the affidavit report filed by the respondents and the letter dated 19 November 2025. This court finds that the authorities have admitted that the petitioner has completed his work for a total sum of rupees 1,73,182. But and it is also admitted that the amount has not been released. Accordingly, the full stop. It is also found that the block development officer requested the district magistrate for release of the fund so as to enable the block development officer to pay the said amount to the petitioner. Accordingly, the district magistrate, the respondent number 2 is directed to immediately to sanction the said amount within a period of 6 weeks from the date of receipt of this order, and on sanction of the said amount, the the block development officer is directed to pay the said amount within a period of 2 weeks from the date of the approval sanction of the said amount. It is further find it is find that since the petitioner has completed the work in their 2020, 2021 and 2020, but and the respondents have admitted that the payment has not been made. Accordingly, respondent is also directed to pay the interest at the rate of 6% per annum. 6% per annum from the date of completion till the date of realization of the said amount. WPS disposal. Next.
Consider 10%. Lordship has division bench judgment. Lordship consider and
take. Next.
Lordship, I am for the state authority.
The same.
Your Lordship, the
amount is the difference. My claim was 6,20,200, but the authority concern has found I am entitled to 6,21,000. So the 1,000.
Yes, admitted.
Your Lordship, yes, but we have asked for the fund from District Magistrate Office.
This is the same letter, my lord. Is
On page 67, Your Lordship.
67?
Yes.
What? Requested the same thing?
Yes, Your Lordship.
19.
Same document, same.
Yes, same. Mothurapur 2.
You will change the work order, work number, record. The petitioner has filed the present date application praying for a direction upon the respondent authorities for release of an amount of rupees 6,20,000, 6,20,200. Counsel for the petition submit that on 21st of September 2020, the Block Development Officer Mathurapur Roman 2 Development Block South and 24 Pargana has issued the work order for reconstruction of Remani Koti, whatever. Full stop. As per the work order, the petitioner has completed the work and submitted the bill, but in spite of completion of the work and receipt of the bill submitted by the petitioner, the respondent authorities are not released the said amount. Accordingly, the petitioner has made several representations, but the authorities are not released the said amount. In terms of the order passed by this court, the authorities and the respondents have filed affidavit in opposition disclosing the document, admitting that the petitioner has executed same amount account 6,21,097. उसमें पूछा है लेकिन इसमें दे देना 6. You have paid for
6,20,200, but they have come after considering my document 6,21,000.
From the report, it is found that the petitioner and the respondents have admitted the amount of rupees 6,21,097. Accordingly, the district magistrate.
The same.
Affidavit. 6. Next.
This is the same block, same work order, same report.
You are the lucky enough the authorities are admitted your claim. Otherwise, I could have been dismissed the writ application.
Otherwise, I will not file this case. Kindly see the communication which has been handed over last.
Send a query then. Dispose of.
This is the same.
How many matters?
9.
Till?
29.
27, 28. All our reporters there?
Yes,
okay, call. 27. Yeah, we care 27. Give the 27 report.
This is the report. Here is this is my amount because of the 1 lakh.
Report in the document. He will pass. He will type it. 27.
I appear for state. The only thing, Millard, in this matter, Millard, report is ready, Millard, but it could not be affirmed because video has not come.
it is unaffirmed report.
This is
Which
Same,
report is there? Same.
same, we have also asked DM to release the form, but it is not affirmed, my lord.
Not affirmed.
Not affirmed.
But give this report. I am taking this. report.
annexed. Yes.
But it is not affirmed, my lord.
Not affirmed. So
Not
what can be done?
My lord, may I come back next week? So
28 not today. 28 not today. Next. 29.
Lordship, I am appearing for the state lordship.
29th.
Filing my report lordship and
All of these are same.
as we have ready to
29 same.
reimburse the claim lordship.
The report. তারপরে
ঠিক আছে করে দেবো তো
In income,
নেক্সট
lordship.
30, my lord, the report is required. Because of that, I have, my lord, this total claim about.
you give
Oh,
30
sorry, my lord, 30. Sorry, my lord, this is not mine.
কত হচ্ছে এটা?
30.
30, my lord, I am for the municipality. Last request, my lord, was supposed to direct us to submit a report in the form of affidavit. Now it is ready, my lord. I have served also copy.
who is for the petitioner?
My lord. Lord, they were permitted to use any exception, but they have not filed any exception.
You not file an exception?
No, my lord. Kindly,
Then
kindly give a short passover, my lord. The
what passover?
council is on his way.
What is the prayer?
Exception দেবে নাকি? Exception দেবে না কোর্ট জিজ্ঞাসা করেছে। Exception দেবে
Putting
কি?
aside the memo dated 4/8. Yes. You have filed the exception or you will not use the exception?
Exception পাইনি।
One opportunity, my lord.
The respondent number 2 and 3 have filed the affidavit after serving the copy to the land council for the petitioner. Council for the petitioner place for time to file reply. Report filed report by way of affidavit. Respondent number 2 and 3 have filed report by way of affidavit after serving the copy to the land council for the petitioner place for time to file exception. Let exception be filed within 2 weeks.
2 weeks, yes.
Within 2 weeks. List the matter on 19th February under the same heading. Next.
Only my lord, one humble submission, my lord. The report, my lord, they had dealt with, my lord, the repetition itself. On the last occasion, my lord, prior to the report being, my lord, being ready, I filed a supplementary affidavit, my lord, annexing, my lord, a few more documents, my lord. Those have not been, my lord, dealt with.
Okay, next.
They are
Next.
My lord, I appeal for the state respondents. Oof.
Have you filed the report?
Yes, fine.
Respondent number 2 file report.
Yes, yes.
I filed the report. Report এখানে দেওয়া নেই?
আমরা দিয়েছি আমরা এক্সেপশন ফাইল করেছি
Yes.
We have also filed our exception.
File the exception. No. Exception is not on record.
আরে দেখো তো
Exception আছে কি দেখো?
দেখেন excuse my importance to remind your lordships. On the last occasions, my lord just put my friend one questions, and then I entered them. No, Mr. With a smile, of course. No, Mr. Banerjee, there's a arbitration clause. So naturally,
That is the
yes. Now, I've just prepared a short note, as we always do for the conversation of the court. There I've clarified, my lord, I can. I'm extremely sorry, my lord. I do not know how to stop, how to open. That is the problem. So that's why. So actually here, there is no such provisions. I'll just collect a picture. File করনি নাকি? So today I'll just raise this point. The next day ছেড়ে copy. ওই তো পড়ে আছে file করো। আচ্ছা। Well, I'm sorry. I'm bringing unconditional apology. It has lying in our hand.
Yes.
বলো এরকম আমরা না 500 বল হ্যাঁ কিছু বলবি
Yes, any problem?
No, no, there is no problem. I was just requesting my learned senior and mainly your lordship. Your lordship will be taking up the full hearing today.
Both party ready?
No, no, I'll tell you, lordship, I am ready on the merits.
Mr. Banerjee knows.
I am ready.
Long time.
I am ready, and he knows me from the day I've entered. But I am ready on the merits with the decisions and everything. Only thing is that, my lord,
time.
No, now time also hardly anything for me. 10 minutes, 15 minutes. My lord, only thing is that, my lord, there is some a situation where I need to be personally present for some invitations and everything.
আমার কোনো আপত্তি নেই but that may be
But
kept
this
in
is
the-
not what I should be submitting to your lordship. But
না না সেটা নিমন্ত্রণ করিসনি
হ্যাঁ করেছি
নিমন্ত্রণ করেছিস
হ্যাঁ করেছি
Before this court, there is no something personal.
But he is rebuking me if I have invited your lordship.
And his father was my friend. It is no more with us, my lord, anyway. So there will
Okay, I am fixing next date.
very well, my
Lordship will not take me amiss.
না না আমি শুনি কোনোদিন দেন না
The respondents have filed the respondent number 2 has filed report, and the petition has filed exception to the report. Let the same be kept with the report. List the matter on 12th February.
12th February.
Under the same head. 12th February under the same heading.
I'm deeply obliged.
But I have already served this short note.
Yes, yes,
Let me kept in the record.
Short note be kept with the record. Short note filed by the petition be kept with the record.
I'm deeply obliged.
বলবি তো এই যে আজ কিছু আপত্তি
না, না,
নেই। May I leave, my lord? May I leave, my lord?
Ajay Kumar Dhotre appearing in this matter, my lord, he has not come in the
Who?
kindly note this.
Respondent. Who is for the petitioner?
No, my lord, petitioner.
Petitioner. Not today.
My lord,
34.
my lord, Mr. Arkodipta Sengupta is appearing on behalf of the state. He is not well today. Kindly bring for not today.
Not today.
I'm for the petition, your lordship. Lord, in this matter, Lord, I have challenged the bank's decision to classify my account as NPA, Lord. And my lord, the malafide is so reflected that on 29th of January, bank by a email communication asked me to pay 7 lakh rupees. Otherwise, my account will become NPA. My lord, acting on that communication, my lord, I have paid more than 7 lakh rupees. Now, my lord, sometimes in July 2020, my lord, 2024, my lord, I came to learn that my account has become NPA on 28th of January. This is the malafide, your lordship. Now, my lord, if my lord kindly takes up my supplementary affidavit, your lordship, I have annexed the RBI regulation. Lord, it is starting from page 10.
It's argued the matter. The matter was argued.
Yes, my lord has passed the
Interim.
My lord has asked for some queries to before the bank. So we have asked those queries for settlement or something, but we have not received yet the answer
Which
from
bank?
It's
Which bank?
number HDFC.
HDFC.
Number 2 and 3. Yes.
So
My lord,
you are appearing
we are
for?
praying for respondent number 2 and 3. We are praying for a few times so that
My lord, the talks of settlement, there in between, my lord, there was a talk of settlement going on that has not been fructified, your
Can I
lordship.
send this to the mediation?
My lord, I have to
Stay
take
order
this down.
continue. Stay order continue. Let I am sending the matter to the mediation. Let you settle it.
Kindly grant us 2 weeks time. In the meantime, if there is no fruitful result is coming, then
My lord, may I just indicate one thing? My lord, they have annexed a chart with their, my lord, affidavit in opposition. My lord, we have brought to my lord's notice that that chart is not correct, your lordship. If my lord kindly takes up the AO filed by my learned friend, kindly takes page 15.
You.
But this matter was earlier with another bench, my lord, with court 24, your lordship. But my lord has released this
Released.
matter.
Yes, where is that?
Termination, my lordship. My lord, they have, my lord, said that the actual copy was with the records, but while the transferring the deed,
It
your
is
lordship,
not here.
it's not there. So they have given a copy of theirs, my lord.
Yes.
Yes, yes. No
My
problem.
lord, lordship kindly comes to page 50. My lord will see that this chart is starting from 1st of November 2024. If
Yes.
my kindly comes to the description part, interest debited till 31st October 2024. Now, my lord, they have omitted to state that on in 31st October, my lord, we have paid 3,19,000, which exceeds the interest amount. This, my lord, they have not mentioned. Then we have brought this.
My lord, the
my lord's
matter has
notice.
been heard at
My
length.
has directed them to file a supplementary affidavit. Lord, whether they will file that supplementary affidavit or not, my lord.
Okay, let they come. When you will come?
Kindly grant 2 weeks time.
Next, I will not adjourn. Then I will pass appropriate order. Take instruction or otherwise.
My lord, 2 weeks. My lord has extended this the interim order till 10th of February. My lord, kindly extend that.
10th of April.
February.
10th of February interim order.
Lord,
Learned counsel for the bank submits that he has not received instruction and request and prayed for 2 weeks time. Accordingly, as per the request made by the bank, the case is adjourned. Let the matter appear on 20th February 2026 or until 2026 under the same heading. The interim order is extended. Though interim order is till 10th of February 2026, the same is extended till 24th of February 2026 or until further order. Huh?
I can be fixed.
Urgent motion, it will take time, then you will go to April. Next.
Well, in this matter, I beg to on behalf of the state. Well, yesterday I have got the instruction from the concerned block land and land reform officer. Sorry, block development officer that 1,75,187 is the entitled. Well,
Item 29.
There's no report.
my lord, I have got the instruction through mobile. Yes.
That is sufficient.
You get it print.
Print দিয়ে দে।
Identical item number 29.
You can give the print.
My lord.
Print दे दे हमारे
দিয়ে দেবে।
ठीक है
My lord.
Dispose of.
Print দিয়ে দেবে।
But your report give, otherwise I will not.
Yes,
Yes, take the report from them.
যাও এক্ষুনি বলে।
Give to the other side or your court also.
Yes.
And you also supply here.
মাল।
তুমি আমাকে দিয়ে দাও আমি print করে
Yes,
আনবো।
next.
The same hearing.
Lastly, Lordship, acted as to file the report in the form of affidavit. Lordship, I am filing my report, Lordship.
2,85,500.
That is the admitted amount, Lordship. And we admitted the amount, Lordship. We have sent a letter to the DM for the sanctioning of the amount, Your Lordship.
Same. Item 37.
37, my lord.
Yes, dispose of.
Correct.
Next.
Number 2, the council is on his way. So if a small passover may be
Yes,
granted.
who is for the petitioner?
I'm being led by Mr. Banerjee. He is also.
Yeah.
Which Banerjee?
And also, if this may be kept on record,
Yes.
there's a report.
Respondent bank. What you are filing?
So it's 2 reports on behalf of respondent number 2.
Yes, you got. Have you gone to the report?
Yes, your lordship.
This report?
Yes, your lordship.
Have you got this report?
Yes.
So,
Yes, my lord. On the last occasion, we had furnished our reports and indicated that the primary purpose of their petition has been served. My lord, they had challenged the freezing of the account, but we have already defreezed the account. They had sought some accommodation before your lordship only to take instruction and indicate to your lordship.
My lordship, since we have been led by my senior Rohit Banerjee sir, as he is not available, my lords, I would like to assist my lords on few points. As the report submitted by my learned friend representing the bank, and he is making statement that they have unfrozen our account. If my lords will see that they have arbitrarily deducted around 14 lakh rupees, that too, my lords, without any valid claim of theirs. It is only because when I approached this honorable court, the bank has realized that they have done some wrong activities, so they unfroze it. My lords, on first instance, before my lords, they have said that they have done everything on the basis of NPCI, on instructions from NPCI. NPCI in their report, my lords, very clearly states that no, we have nowhere asked banks to froze the account. So my lords, after the submission of NPCI's report, they have unfrozen the account.
yes.
And my lords, there has been a lien mark to my account without any valid justification to it, and the bank is absolutely silent upon it. Bank has nowhere said that they have deducted the amount, they have marked lien, and now they are claiming it as a recovery, which is arbitrary, my lords. So this is, I would only request my lords to not dispose of this matter, as we are being led by my senior Mr. Rohit Banerjee, sir, and he is on his legs with some other court, my lords, and I am appearing through VC, my lords.
The respondent number 2 has filed the report after serving the counsel for the petitioner. Counsel for the petition prays for time. Is adjourned. Let the matter appear in the combined monthly list of March 2026.
My lords, I would request from my lords not to place this matter in March, my lords. If my lords can bear me, my lords, I have filed this matter in the vacation bench. My lords, this is.
Two matters, same. Two
My
matters.
lords, there are 2 matters. My lords, the second matter, my lords, there is still a lien marked on this, my lords. My lords, I have salaries to pay to my lords employees. My lords, I am running a diagnostic center, my lords.
Second matter, no report is filed.
No, my lords.
Both matters.
No, already filed.
Already filed.
That only.
My lords, this matter reads my lords' consideration, my lords. My lords may not place it for March.
My lord.
Yes. April.
No.
Short passover is April. Either you do the matter. You all persons are mentioning the matter coming in my senior. That's why that is the problem. If it today will not do, I will give in the matter in the month of April.
My lord, I'm late appearing on behalf of the petitioner, my lord. My lord, lastly, the matter was taken on January. My lord,
I'm for the state also.
they are supposed to file a report.
Who? Yes.
Your lordship, I need some more time to file a report.
What is going on?
Your lordship, I was not aware.
7th January. Now we are February, reaching February.
Kindly give us 1 week time, I will file.
So whether the matter was placed before the review committee is considered, if not considered, what is the reason for not consideration? That is the thing.
I will file a report. Your lordship, kindly give me 1 week time, I will file.
As per the prayer made by the counsel for the respondent state, the case is adjourned. Let the matter appear on 11th February.
Grateful.
Next. Next.
Lordship, 41, I am for the state, Lordship. Lordship, the matter has not been placed before the board, Lordship, till now. There is so many queue, Lordship. No, no. Okay. And earlier that was
When he was
rejected.
when he was convicted, 2003. Till date, here this matter has not been placed before the committee.
Lordship, once that was placed, that was cancelled. Again, that application, Lordship.
Have you got
Earlier rejected, Lordship.
What is the name? Kajal Kumar Mitro. Huh? What is the name of the brother? Convict. What? Shekhar Bishon Mitro.
Item number, page 329, Lordship.
Discipline force, they committed the crime against women following which they committed heinous murder. So this page number 3 of the report.
Lordship, that is not
Correct.
recommended.
Not recommended. How you got this report? Is the police authority has given any report?
Lordship,
Whether at the time of parole he has committed anything? He has
Lordship,
stated that he is strong enough to commit a crime. The convict expressed his willingness to join family business. So and so, so and so. Have you received the report from the concerned district police before considering this?
this report has been placed before us. That is
Oh,
Lordship. For Lordship, direct me to take further report, then I will.
Correct. If you want to place the name of the convict before the remission committee, first you have to ascertain the total report from the district judge, from the police, concern SP, and then the family members. Then it has to be considered. And if it is not considered, then it has to be sent to the High Court. There is a committee in the High Court. Then the High Court will also consider whether it has to be reconsidered or not.
As on date, Lordship, they have filed that. As on date, I have received that report, Lordship.
So, what is the offense? 302. To whom? Who is the victim?
One sergeant, Calcutta police sergeant was.
Calcutta police sergeant, you have committed of the murder of the Calcutta police. So that's why they will give the favorable report to you.
At that time, it was ordered by the court.
Whether he has not preferred any appeal.
Yes, my lord. That was upon 5 days honorable court.
And Supreme Court also. No. They not went to the Supreme Court.
But allow he is now I will annex the order, my lord. Is 103.
$108. When 08 is with other matter.
Lordship.
See, one already and 2 people were lordship and
Person to person, that will always vary, Lordship.
Who has issued the character certificate? Who has issued? Jail authority.
Yes, my lord. Superintendent of Calcutta audited their correction.
So why are not recommended? Detained in sense is He is in custody since 2017. Kindly come. He is presently detained at this
The pre-construction seems dead, but he was convicted.
Murshidabad Admitted Presidency 2003. 2nd January 2003. And since then he was serving as a rigorous imprisonment. Now he presently detained in the correctional home since 4th October 10 and found trustworthy, disciplined, sincere and most consistent. Yes.
Lordship, that report has not been placed, but along with this report submitted by the state lordship. How they have collected the report, that is not the.
Where is that? When he was released on parole. 71. Yes. 15 days certificate. What is this? What is the 70? Convict Shekhar Basu, presently detained in Loga Air. Yes. So he was released on parole 12 December to 9 January. Just then paragraph 70, 72. Then 73. Yes, then 5 also. Yes. Till page 89. Yes. Yes, what is the contention, sir?
Lordship, kindly allow me to take further report.
What?
That is no, whatever report is there, Lordship. I cannot.
30th January. But the last 23 years I am in custody.
The petitioner has filed the present writ application praying for a direction upon the respondent authorities and praying for setting aside the order issued by the respondent authorities and passed by the State Sentence Review Board, being memo number 619/RB dated 14 September 2022, wherein the request of the petitioner for premature release is rejected. Where is that memo? Is rejected. Full stop. Counsel for the petitioner submit that the petitioner was convicted by the Learned Court of which court which was connected? Where is the trial court order? Then where is the trial court order? Where is the first conviction? And before the conviction, he was in custody or he was on bail? Where is that? Because he was arrested. Whether he was during the trial, he was on bail or he was in custody since the arrest. You have to ascertain whether he was in bail or not. He was under trial. The trial was conducted as an under trial prison. That's why you have to bring on record, and the session judgment is required to be brought on record. Get it then. The learned counsel for the petitioner prays for time to file supplementary affidavit by disclosing whether the petition, whether the convict was in custody during the trial or not. Full stop. Let the supplementary affidavit be filed by within a week. Full stop. Report filed by the state be kept with the record. List the matter on 11th February 2020. Give the report. Yes, next.
Next, my lord.
I
am for the respondent number 4, college.
Which one?
আমাদের এইটা নেই
Which one?
42.
Was completed.
Grateful.
The entering authority, respondent number 2 has written a letter to the respondent number 4, who's the college, seeking release of my admittedly due amount. And we have been told that because that amount is not being released, so we cannot be paid. This is the
not be released.
That amount has not been released by the college to the ADM, so ADM cannot make a payment to me. That is the reason why the payment has not been made.
Where is that?
May I just take a to that admitted letter? Lordship will kindly take up page 30. Lordship, this is a letter written by R2 to the principal, saying that enclosed signed here with the information given in Annexure A, which speaks for itself. I would like to present my request to allot the required fund to complete the execution of work as per proposed estimate. Also to inform you that beyond proposed estimate, we have executed some additional items of work as per verbal discussion made with you. I am annexing Annexure A. Lordship kindly takes up Annexure A. Number 2, my lords, proposed 2-storied girls hostel. I have completed this work. Lordship will kindly take the last column, 100% complete. My work order is also there, Lordship, where I have
2,56,58,000.
Yes, Lordship. This is the amount that I'm seeking.
25,65,000.
65,881. I'm seeking disbursal of this, my lords. My lords, the work completion certificate is in page 25.
25.
Lordship will kindly see.
When it was issued?
Lordship, this was issued in 2021. There was a 36 months period that I had to give them in order for them to.
So amount paid 7 crore 20 lakhs.
72 lakhs, man. 72 lakhs, not 70.
Yeah, 72 lakhs.
72 lakhs. Work amount done, Lordship will take 0.6. 97,65,881. So this difference, man.
So that is 25 lakhs.
This 25 lakh 65. This is difference. This is admitted. Now, Lordship, the tendering authority, Lordship is R2. Lordship kindly takes up the tender, page 21.
Yes, who is appearing for the authority?
My lord, for the Jila Parishad, my lord, I am appearing, my lord.
I am
appearing for the state. I have to take some instructions.
Who is for the Jila Parishad? This college.
College, they are appearing. Everyone's appearing.
College?
College, your lordship.
Yes, what? You have not released the amount.
As well as the university grant commission for releasing of the raised amount.
Where is that? Where is that? Where is that? You requested the Jila Parishad. Jila Parishad requested the principal.
These are my instructions, madam.
relevant annexures is there.
This is of 10 March 2023. And this is of 21. Regarding release of the amount. Different UGC. What is UGC?
University Grant Commission.
Yes. So, what can be done?
May I say this, my lord, lordships aware, I am carrying a judgment of the coordinate bench where it has been categorically held that after a tenderer who has completed his job, he cannot be made to wait on these aspects as to who will make the final payment.
Who has issued the tender?
Lordship, respondent number 2.
Bankura Zilla Parishad, your lordship, find at page 21.
And
My lord,
additional
here, my lord,
executive officer,
may I-
lordship, takes up page 21.
Yes.
If I may just put one thing clear, though it is being issued by the ADM of Bankura, but it has been issued in the capacity of executive officer of the Zilla Parishad. Hence, it is
Correct.
the statutory authority.
Correct.
It is by Bankura Zilla Parishad.
Correct.
Hence, the tender issuing authority is Bankura Zilla Parishad and not the ADM.
Correct.
Not. That is my
My lord, page 30, my lord, if your lordship, page 23 is the.
Page 30.
My lord, this is the last communication which I found, my lord, from the writ petition.
Correct. You made I am passing an order.
Yes,
Appropriate authority will approve the sanction, approve the amount, and once they approve the amount, the Jila Parishad will release the amount in favor of the petitioner.
Yes, that has to be approved by the principal of the court. Just fix a timeline.
The petitioner has filed the present writ application with the for a direction upon the respondent authorities for release of the admitted amount of rupees 25,65,881 along with interest. Counsel for the petitioner submit that on 28th of December 2015, the Jila Parishad, who has issued the tender? The office of the respondent number 2 has issued the tender.
Yes.
Tender for which work? Where is the work?
Lordship, page 21. Lordship kindly takes up page 21. Tabular. There are 6 works. Work number 3 is what I have.
With respect of the proposed 2-storied girls hostel building over 3-storied foundation for Sonamukhi College in Bankura. Full stop. As per the tender, the petitioner has participated in the tender process and the work order was issued to the petitioner on 28th of January 2016. As per the work order, the petitioner has completed the work and the district engineer Bankura Jila Parishad has issued the completion certificate certifying that the total work done for a total the petitioner has executed the work for a total amount of rupees 97,65,881 and the work was completed on 31st of December 2020 and out of the total amount of 97,65,881 an amount of rupees 72 lakhs has been paid and the remaining and the balance and an amount of rupees 25,65,881 is due to pay the petitioner. The petitioner has made several representations to the authorities, but no amount has been paid. Full stop. The additional executive officer Bankura Jila Parishad by a letter dated 3rd of December 2021 has requested the principal for release of the fund so as to enable the petitioner the Jila Parishad to release the amount in favor of the petitioner. But in spite of the said request, the school has not the college has not released the said amount. Learned advocate appearing for the college has submitted that on 3rd of October 2023 has informed the additional executive officer Jila Parishad that till date the amount has not been sanctioned and as such it is not possible for release of any amount. Police heard the learned counsel for the respective parties. This court find that It is admitted by the authorities that the work order was issued to the petitioner and the petitioner has completed the work for a total sum of rupees 97,65,881. Out of the total amount of out of this aforesaid total amount, 72 lakh has been paid and the balance is still due to pay to the petitioner. Full stop. There is a dispute amongst the authorities that one authority has not sanctioned the amount and as such the Jila Parishad is not in a position to release the said amount in favor of the petitioner. Considering the above, this court find that the due amount and the amount is admitted, the respondents have admitted that the amount is due on account of the petitioner. Accordingly, the who will sanction the amount?
The principal. This point number 4 is the principal, my lord.
Accordingly, the respondent number 4 is directed to sanction the amount of rupees 25,65,881 along with interest at the rate of 6% per annum from 31st of December 2020 till the realization of the said amount within a period of 6 weeks from the date of receipt of this order. And once the amount is sanctioned by the respondent number 4, the respondent number 2 shall release the said amount in favor of the 2.
Yes, who will release the amount? He will
2 shall release the said amount in favor of the petitioner within a period of 2 weeks thereafter.
Kindly add one line, Malad. Kindly add one line. Malad, the amount which is accrued now, Malad, that is tune of rupees
25 lakhs.
25 lakhs. That was due to some additional work that has been done, Malad.
That's it.
Yes,
The
Malad, it
counsel
is
for the
from my letter,
respondent-
Malad.
Counsel for the respondent submit that the said due amount is with regard to the additional
Malad.
And thus sanction is required.
The college has taken initiatives to release the fund from the university grant commission, not yet done. College authority is helping.
The college authority is directed to
Authority concerned.
पर बोला ना the college the respondent number 4 is directed to sanction the said amount by taking appropriate step before the appropriate authority within a period of 6 weeks after receipt.
I'm so grateful. One indulgence, Milord, if your lordship kindly consider.
Yes.
38, 39, Captain.
Second half.
Milord, I had a talk with the higher ups. Milord, we are coming up with a notification, rather a modified roster, 100-point roster. But it is yet to, Milord, see the light of the day. Maybe within a day or two, Milord, it would be published. So I would be praying if your Lordship may kindly take it up on next Wednesday. By that time, I believe, Milord, notification would be made. Kindly do not record my submissions, but Milord,
Add on to my Lord, senior friend, Lord. I have a list which was already, I have a list of candidates who have already been selected pursuant to the existing 100-point roster, and their name is transpiring. The list has been published by the government. Well, maybe during the interim, I do not know what is coming up. Such candidates may be extended with the benefits of this selection process, and we may remain unstranded. I was requesting a lot for limited interim order to that effect.
For what?
For having the post of SCLD stay till such time.
Matter of 4 days, let it come on 4th
Yes.
of February. As urgent motion in the top, I am keeping.
your Lordship may keep it, Milord, at 2 o'clock.
2 o'clock, other matters are fixed.
अच्छा, any time.
4 तारीख को तो 2 बजे
ওটা
fix है।
মনে হয় তো সহজ ব্যাপার এত
है
কথা
ना,
বলতে
top में कोई है?
বলা তো যায় না। আরো কিছু।
12 बजे है।
আরে নোটিফিকেশন দিয়ে দেবে যেদিনই থাক না কেন।
351 है, नहीं 12 बजे है। 12 भी है, 2 भी है।
তুই কি এখন 11 যাবি?
Can it the urgent motion top 10:30?
10:30. But on Wednesday, your Lordship is speaking
Wednesday.
of.
On 4th February.
That's not a mentioning day, I believe. That's not a mentioning day. Every day is mentioning. Huh?
No, Wednesday is not mentioning, but every day they are coming. As per the prayer made by the Advocate General, the case is adjourned. Let the matter appear on 4th February under the heading urgent motion at the top.
That applications be allowed of addition of party.
I will take, don't worry.
Deeply obliged.
Take care of all things. Yes. Now you got the chance. Now you got the chance. Please wait, because the court has to see all the things.
Problem for client is
I appreciate. I appreciate. I appreciate. But
And he's calling my phone.
I appreciate.
That's
I
why-
had faced that problem. No.
The supplementary affidavit I am filed by virtual. Now, my lord, the petitioner is a Kaju nut suppliers.
What supplier?
Kaju nut.
Kaju, cashew nut.
My lord,
Hmm.
Kaju nut. Now, my lord, he imported the raw Kaju
Ah.
from different countries and from different states of India
Hmm.
and processing here
Hmm.
and now import the same to Bangladesh, to other countries and to different states in India except West Bengal. Now, my lord, the marketing committee is intentionally levying the charges when the Kaju nuts are coming from different countries without in contravention of the law. Now, I moved the writ petition before this honorable court. The honorable court passed an order. Kindly see the order, page 23. Well, I am reading that order. This order is very important. Page
23. Yes.
On perusal of the report forwarded by the Secretary, Purva Midnapur Jilla Regulated Market Committee, dated 10 July 2025, it appears that the committee is levying fees on the petitioner in terms of Section 17A, read with Section 21A of the West Bengal Agriculture Produce Marketing Regulation of 1972. Specific case of the petitioner is that the petitioner is neither purchasing nor selling the agricultural produce within the area of the regulated market committee
The petitioner hereby imports cashew nuts and processes it within the jurisdiction of the Regulated Market Committee and therefore sells it of elsewhere. The petitioner refers to section 17(1) of the Act, which clearly mentioned that notwithstanding anything contained in any other law relating to the taxation of the agricultural produce in force, the marketing committee shall levy fees on an agricultural produce purchased or sold in the market area. Kindly say that. According to the petitioner, as neither the purchasing nor the selling of the agricultural produce takes place within the market area, accordingly fees cannot be charged. The contention of the petition appears to be in line with the provisions of the Act. The authority ought to first decide as to whether the fees will be payable or not and thereafter charge the fees. In the instant case, Regulated Market Committee has acted mechanically and has levied fees upon the petitioner without proper adjudication whether fees will be payable by the petitioner. The chairman of the marketing committee is directed to inquire as to whether the subject agricultural produce is either purchased or sold within the jurisdiction of the regulated marketing committee. And if it is found that the submission of the petitioner is proper, then refund the amount illegally collected from the petitioner on the account of the market fees. A decision shall be taken by the chairman within a period of 6 weeks from the date of the communication of the order. But thereafter, the inquiry committee, inquiry was done. And kindly see the inquiry report, page 25.
Yes.
The Mesa Sunjeev Kaju Processing of Village, Pania, Post Majna, PS Conta, District Purva Midnapur, is a Kaju processor as it is mentioned in the aforesaid order of the Honorable High Court in Calcutta. From the challan as attached herewith, it is evident that on 31st March 2024, Mesa Sunjeev Kaju nuts purchased 12,700 kg of Kaju nuts from a trader named Daud Kaju Processing Majna, Contact Purva Midnapur, at a rate of rupees 110 such and such, only per kg, and the total purchase price including all taxes was rupees 40 lakhs. Only again from the attached UA bill dated such and such, transportation and selling of the Kaju nuts processing industry. According to the rule 2(1)A of the West Bengal Agricultural Produce Marketing Regulation Rule as mentioned by notification such and such of Agricultural Marketing Department Government of West Bengal, business of purchasing and selling of the agricultural produce means purchase to or sell agricultural commodities within the market area by a person, be trader or big agent or buyer or seller or commission agent, processor or his agent, transporter of his agent or exporter of his agent, importer of his agent, cold storage, owners for storage, into such and such. Under section 17(1) of the West Bengal Agricultural Produce Marketing Area, there is such and such, the Kaju processing is liable to be market levy fees to the Purva Midnapur Jilla Parishad and also submit the required bill under such and such. This only transaction has been given, only Dubai South Kaju nuts I have purchased such and such.
Correct.
But so far the other transactions are concerned, they cannot produce any of the one bill because I have supplemented everything, I have arranged all these transactions 2023, 4, 5, all transactions I have given, invoice given, all these transactions from the outside of the country and from the outside of the state. Only this transaction was actually taken place. We are ready to pay this amount. I don't worry about that. But so far the transactions which are affected in outside of the India, in different state of the India, how you are trying to stop this, detain these vehicles and charging this levy? Because 17(1) is very much clear.
So how this 12,700 kg of cashew, so you have loaded in
This transaction has been taken place from Dubai Kaju nuts, who has given the levy, fees on that production. But the section 17(1) provides you cannot charge double levy in one product. Therefore, when you have taken a levy from in respect of that Kaju from Daud Kaju nuts, you cannot charge another levy in respect of myself. Therefore, this is also illegal. But so far other transactions are concerned, this is not taken place within your marketing area. How can you impose levy? But this is there is a bar of the sections. This is now, kindly see the supplementary affidavit.
Who is for the other side?
When I am giving notice.
Yes.
Now can you see page 25?
25.
Page 25.
Yes.
Now can you see address bill, Sanjeev Kaju processing?
Yes.
As well as this space from Mazda. This is also sale quantity. This is not within the area of that marketing committee. Can you see? Ship to
No.
Varanasi,
This
Uttar Pradesh.
paragraph 25, page 25. This is addressed at e-way bill.
Yes, you will. Now, where this Kaju has gone, can you see? Right hand side. Ship to. Can you see? Woodbury Road, Bola-Ratna, Varanasi, Uttar Pradesh. Therefore, the Kaju has gone there. Now, can you see next bill?
So where from you got?
Not raw Kaju, not.
This from cash. Okay. Ma Trading has purchased from you. No difficulty. But where from you purchased?
I purchased this Kaju nut, raw Kaju nut from different state and different country.
So that's why so this is a difficulty with the authority. So you are selling from West Bengal to Uttar Pradesh. Okay, you are not selling in the West Bengal. No problem at all. But this what is the quantity? 500 kg. This 500 kg, where from you got?
But this Kaju nut is processing here. But this Kaju nut is coming from different country.
So
This is
that's
the raw Kaju nut. It's coming. I will show the slip, the voucher, purchase voucher.
Correct. That you have to show
Yes,
that this 500 kg kaju, this was brought from elsewhere to your factory, and after the process for cleaning and all these things, then you have sent to the Uttar Pradesh. Correct. Ma Trading.
Can you see the purchase? Can you see? Page 134. Left hand side, can you see? Purchase. Now, where from is purchased? Yeah, right hand side, Cochin. Anybody got it?
Supplier, buyer or supplier?
That is.
So this is from Kerala.
Yes, Kerala. And Navi Mumbai also. Navi Mumbai. Therefore, this purchasing and selling would not be taken place within the area of marketing committee. Sir, if it is not taken place within the area of marketing committee, how the marketing committee can charge levy?
Where is the act?
Act. देखो तो वाला 17 subsection 1.
Where is the part A?
Hello?
Part A.
Party.
Part A.
Party. Partimony group.
Yes, what is?
This is
Select
schedule of the agricultural produce.
fibers.
Kaju nut is there.
Huh?
Kaju nut is there.
Yes, cashew nut. So, for an item, the agriculture produce the specified part A of the schedule at the rate not exceeding 2% of the amount for which the agriculture produce is purchased or sold, whether or cash or the deferred. Purchased or sold where?
Yes. Purchased and sold within the area.
In the market area.
Yes, within the market area.
In the market area. Okay. So what the authority says? Owner of the transfer warehouse 2AA 21. Where is the rule 2? Where is the rule?
Rule 2 of that rules, madam.
Yeah.
Of that rules. West Bengal Agricultural Produce Marketing Regulation Rules.
West Bengal?
No, West Bengal Agricultural Produce Marketing Regulations Rules.
1982.
21AA.
Where is the 21A? Show me. एसी नहीं एसी नहीं चलता क्या क्यों क्वेश्चन तो एसी डाल बोलो Where is the 21A?
The 21A has been defined here. Can you see? Page 25. Page 25.
West Bengal Agricultural Marketing Rules as amended by notification.
Page 25.
Dated.
According to Rule 2, Sub-Rule 1, AA of the West Bengal Agricultural Producer Marketing Rules as amended by notification that of Agriculture Marketing Department, Government West Bengal, such as business of purchasing and selling of agricultural produce means purchase or sale of agricultural commodities within the market area by a person or by a trader or his agent or buyer, seller or his agent, importer or his agent, cold storage owner or owner of storage.
Within the market area.
Pardon?
Within the market area.
Within the market area.
Who is for the state?
Mr. Spokoman is appearing for respondent number 6, my lord.
Where is he?
He's on his legs before 236.
Respondent number 6.
Respondent number 6, ma'am.
Secretary Jilla Parishad. Jilla Regulatory Marketing. Yes, he is the authority. So how this order can be passed? Have you act? You are having the act?
No, my lord. I'm not in this matter, my lord. I'm state by this Spokoman. Kindly make it not.
What is the grievance now?
Now, my lord, my Kaju nuts would
What you are challenged?
No, I am challenged that I am not in a position to pay the levy because my
What you are challenged, sir?
challenge kindly.
What
say,
is the prayer?
the order was passed, we have to pay the levy. That was subject matter of challenge.
This order is challenged.
Yes.
9th August.
Yes,
9th August
yes,
order.
that you have to pay the levy.
Hmm.
That is the subject matter of challenge.
Order dated nil.
Yes, yes.
Where is that order? Order dated nil?
I am giving that order. Order page 32, relevant page 35.
35.
Relevant page.
So you are not challenged this communication. 9th August 25.
The order was challenged.
Where is that order?
Order matter page 32, relevant page 35.
It is not legible copy, sir.
No, I have 35. I am reading that. Kindly see for 35. Reading. Hearing both the parties and considering
35.
35.
Hmm.
Hearing both the parties and considering the inquiry report, including the challan and waiver as submitted by the Secretary General Police Market Committee, Puromindapur, by memo number such and dated such. It is evident that Mr. Sanjeev Kaju possessing his report in purchasing and wheeling Kaju nuts within the jurisdiction of the General Regulated Market Committee, Puromindapur, in terms of Section 71 of the West Bengal Agricultural Produce Marketing Regulation Act, review Route 21AA of the West Bengal Agricultural Produce Marketing Regulation Rules. Mr. Sanjeev
Okay, paragraph 1.
Yes.
Is involved in purchasing and selling the cashew nut within the jurisdiction of Jilla Parishad.
This is only Dube Kaju nut.
Huh?
This is the only Dube Kaju nut.
Correct.
There are no other transaction, nothing of this sort. And they will not produce any one of the bill legally transaction. And all these transactions has been effected in different states of the India or outside of the country.
So what can be done now? The state is not here.
Now, at least one resident not to put levy. Charging food.
Not to put levy can't be blanket. It cannot be. Not to put levy if you're selling.
And if the clarify it.
Who will verify?
No. If the
charge, how the procedure is done? Okay, if you are having the factory or manufacturing factory, where it is the factory?
The factory different country, my factory. In the West Bengal.
In West Bengal. So you are bringing the cashew from outside, other states. Correct. Then you are packaging in your factory and sending it to the other state. So how it can be determined you are not purchased from the local area or not sold in the local area?
Invoice will remain.
Yeah.
Invoice. Because if I purchase, there will be invoice.
So you are sending the materials from your factory. Correct. In the factory, there is no check and balance is there from the state authority. So state authority is stopping you at the checking point. So how it can be ascertained whether in the vehicle, the cashew nut which you have loaded to sending to Uttar Pradesh or Kerala or anywhere. So this has not been purchased by you from the West Bengal. How the authority can ascertain? And if today this court pass an order not to levy and you're purchasing and selling it to the local area of the West Bengal. So
local area, if the transaction is affected, they will charge this levy.
So who will verify and how it can be verified? So kindly see, now you come to the page 25A. 25A, one document has found you have purchased in the West Bengal.
So this is admitted that. That's why they have given a challenge.
So like this, so how it can be ascertained?
If I purchase or sold this kaju within the marketing area, they will give the challan. This is the evidence from the document. But if I purchase some other country, there will be invoice.
Correct. So how this challan has come? You have purchased from the trader name. So yes, sir, you are appearing. That is the main respondent. So how you can kindly come to the page 34 and page 25A. Read both together. 25A, second paragraph, middle portion. Mr. Sanjeev Cashew purchased 12,700 kg of cashew nuts. Got it? 25A. You are having 25A, no? Or 25. You go to 25. I think that it has not. The legible copy is not given to you.
Inquiry report. কত নম্বর পেজটা বলবি 25 এটা পড়ে রাখ এই না পড়ে রাখ
In the second paragraph, fourth line. Mr. Sanjeev Cashew purchased 12,700 kg of cashew nuts from the trader named Dawood Cashew Processing, Tajpur, Majna, Kontai, Purba Mudnapur. Okay.
I have to take instruction. I have understood.
Just a minute. This is okay. This you have identified and put the levy on that. Now kindly come to the page 34, the impugned order. Impugned order, page 34. Got it? A or 1, whatever it is.
All type of. All types.
Mr. Sanjeev Cashew Processing is involved in purchasing and selling the cashew within the. How you got this? For only one document, you can restrain the total products. One thing. Second thing, you also take instruction how you are checking where from he is purchasing, how you are checking e-way bill. If is the materials, the raw materials is coming from the outside, it will be e-way bill, either Kerala or Uttar Pradesh or Delhi or anywhere. So e-way bill produce that yes, it is the product he has purchased. Then while he sending the materials from Calcutta or West Bengal to other place, that is also e-way bill. Yes. So it is not, and if he purchase from the local market will say yes, this is the purchase from me.
Yes.
So this finding, how this finding has come by the district magistrate? Only because of one document, the report submitted by the secretary.
Right.
These two things you have to take the instruction. Then it has to be clarified. So okay, he can leave, but if the authority find that he has purchased or sold the materials, the cashew in the local market, the authority is entitled for that. If it is found that he's been purchased from outside, sending it to the outside, then it is not 17(1) is not liable to pay any. How soon?
1 week, 2 weeks, my lord.
2 weeks.
1 week. Next week.
Learned counsel for the petition argued the matter at length. Full list of counsel for the respondents pressed for time to take instruction to ascertain on what basis the district magistrate has come to the conclusion that the petitioner is involved in purchasing and selling cashew nut within the jurisdiction of Jilla Regulatory Market Committee, Purba Medinipur. Let the matter appear on February 10th February.
10th February.
10th February within 5 matters.
No, only one thing, Mala.
Under the urgent.
Only one thing, Mala. Meanwhile, the cashew nuts is coming from Nigeria. Meanwhile, cashew nuts is coming from Nigeria. But they will charge the levy. This is the problem. But I just kindly clarify it. If it is not transaction within the market area, they cannot.
That's why I asked you to take instruction how they came to know.
The cashew will be coming from Nigeria.
Let it come. You raise the e-way bill. If it is then come.
Well, let it be clarified. I will produce the e-way bill. They will charge. Let it be clarified.
It is clarified that if the petitioner is able to prove that the cashew nuts have been purchased from outside of the West Bengal or sold from the outside of the West Bengal, as per the act, the authorities shall consider the same in terms of section 17 within bracket 1 of the act. Next.
আমি আছি
Kindly see the
for the state.
kindly will not peruse the order dated 3rd of December 2025.
State is director to submit report from the London Edition Sasanja Barasat, Superintendent of Concern, police in charge, and the concern for prosecutor in charge with respect of the case that yes.
My lord, with regard to the prayers of the Milord, petitioner Milord, one of the prayer has already been done, Milord. We have removed the PP Milord.
Huh?
The PP Milord who was looking after the case in the trial court, Milord, we have removed him. Milord. We have appointed a new PP. As for the with regard to the Milord misplacement of the Milord C-Day, Milord, we have found